Good, thanks, and you? the matter of the state versus J.G. Zuma and Thales, South Africa.
Mr. Raja and I appear for the state in both applications.
Ladies the court, my lord. Mr. Masuku, I see Mr. Thales and I appear for the first accused in this matter.
May it please the court, my lord. Ms. Jackson and I appear on behalf of the second accused in both applications.
My lord, the parties have agreed to ask your lordship whether we could address the two applications before you today as follows. We suggest that we argue the two applications together, that the state starts and address you on both applications in 1.5 hours. And then the accused will address you also on both applications 1 hour each, or however they divide up the 2 hours allocated to them. We will then reply in half an hour, and my learned friend Mr. Mpofu reserves the right to reply in the application for leave to appeal for 10 or 20 minutes.
And you are going to finalize the matter today?
The purpose of the exercise is to finish today.
Thank you so much. Right.
We will then start, if it pleases your lordship, and my learned friend Mr. Breitenbach will first address the leave to appeal application. I will then address the stop Stalingrad application.
Yes, Mr. Breitenbach.
Thank you, my lord. In the main application, the accused applied for relief amounting to a permanent stay of their prosecution. Their applications were based on the trial prejudice they alleged they would suffer due to the deaths of two Thales Group employees, who the state alleges were involved in some of the corruption and related offences with which the accused are charged in the criminal matter. The persons in question are Mr. Pietermaritzburg, who, as the court knows, died on the 31st of December 2020, and Mr. Alain Tetard, who died on the 5th of September 2022. In the main application, the accused alleged that if the criminal trial goes ahead in the face of the deaths of these two gentlemen, they will suffer an irremediable and serious violation of their right to a fair trial, specifically the right to adduce and challenge evidence conferred on them by Section 35(3)(I). That application was dismissed, and the accused now seek leave to appeal against it. The state's attitude is that the present applications for leave to appeal should be dismissed as well. We shall start by summarising what we submit were the main findings of this court in its judgment on the 3rd of June, and then explain why in our submission leave to appeal should be refused. In its judgment, this court made 10 main findings. The first was that Mr. Zuma's notice of application made it clear that his application was conditional upon the success of Thales' application. And it follows that if Thales' application failed, his would too. Secondly, the court found that the Thales application for an order directing the state to stop the prosecution in terms of Section 6(b) of the Criminal Procedure Act was incompetent. The reason is the power to stop the prosecution after an accused has pleaded to a charge rests solely, exclusively within the state. This court further found that as Thales' application for an order acquitting it on all of the charges was conditional on the granting of the first order, that order couldn't be granted either. The court then considered Mr. Zuma's application, more specifically his application for a declaratory order in terms of Section 172(1)(b) of the Constitution. Earlier in its judgment, this court had held in effect that Mr. Zuma's Section 172(1)(b) application should also form part of Thales' application, given the history of this matter. With respect, we submit this court was right to hold that Section 172(1)(b) of the Constitution should form part of Thales' application. The reason is in its founding affidavit, albeit not in its notice of motion, at paragraphs 81 and 83 to 85, it relied expressly on Section 172(1)(b) of the Constitution, as well as Section 38 of the Constitution. Having dealt with these preliminary matters then, in the remainder of its judgment, this court considered whether the accused had made out a case for relief in terms of Section 172(1)(b). More specifically, whether, as this court put it, and I quote, the just and equitable order would be to declare that Mr. Zuma and Thales would not receive a fair trial if their prosecution were allowed to proceed in the face of the deaths of Messrs. Moineau and Tetard. In this connection, this court acknowledged that Mr. Moineau was a director of Thales between May 1996 and April 1998, and that from October 2002 to December 2010 he was also a director of that company, and that Mr. Tetard was a director of Thales between April 1998 and January 2002. And having done so, the court then turned squarely to Thales' argument that those two gentlemen were the only individuals who would have been able to testify on its behalf and to assist it in challenging the state's evidence against them. The court noted that Mr. Zuma had alleged that the same applied to him. The court commenced this aspect of the judgment by citing the passages from Botma and else, which were quoted to your lordship on both sides. And having done so, the court made what we submit was its fourth main finding. This finding was that this court can shut the door to a continued prosecution only if it is satisfied that the continued prosecution will cause both accused irreparable or insurmountable trial prejudice. In other words, there is no way in which the fairness of the trial can be sustained. And we pause to interpose that that is indeed the central ratio of the line of cases culminating in Botma and else, and it posed a very high bar indeed for the accused. The court then turned to the evidence. Its fifth finding concerned a dispute between the parties about the state's contentions that Messrs. Sheikh and Dryman, as well as Ms. Gurrier, were available to assist Thales in its defence. In that regard, the court held that given that the applications brought by the accused were to be decided on the papers, the Plascon-Evans principle tipped the scales in favour of the judgment. Sixthly, dealing with a related issue, the court addressed the dispute as to the value to be attached to the evidence of Mr. Dryman and Ms. Guerrier, if they were called as witnesses. We interposed to say that the evidence shows that Mr. Dryman was Thales Group's South African attorney who handled this matter on its behalf for many years. Ms. Guerrier was a senior in-house Thales Group lawyer who did the same. The state's allegation that they must have interviewed Messrs. Moineau and Tetard about their and the Thales Group's company's interactions with Mr. Zuma, that allegation wasn't disputed by Thales, and that formed the foundation for the state's submission. So returning to the dispute between the parties about the value to be attached to their evidence, more specifically the evidence of Mr. Dryman and Ms. Guerrier about what Mrs. Moineau and Tetard had told them, this court held that the accused's argument that any such evidence would have no probative value was speculative. And that was a key finding with respect made by this court. And the reason for the court's finding is that the value to be attached to the evidence sought to be adduced by Thales will only be known once the evidence has been presented. And with respect, that is self-evidently correct. Seventhly, and consequently, this court found that the question whether there will be trial prejudice, which might result in Thales not receiving a constitutionally fair trial, is a matter to be addressed by the trial court when it arises, if it indeed does arise. Turning to Thales' allegation that Mr. Tetard's death had deprived it of an essential witness, this court's eighth finding was that allegation was incompatible with its stance in its 2019 application for a permanent stay of prosecution, that he wasn't prepared to assist it in any way, and that he was not prepared to return to South Africa or to testify in South Africa or any other forum should a trial take place. And this court added that it was significant that Thales had failed to indicate that since 2019 he had changed his mind and was willing to assist it in this case. There was then a dispute about the value to be attached to the transcript of Mr. Moino's evidence during the Sheikh trial, should Thales choose to introduce it. And in that connection, this court found that this was another of the many factors about which this court will have to speculate at this juncture, and which should best be left for consideration by the trial court. And consequently, the court made its ultimate finding, its 10th finding, which was, and I quote, "The court is not persuaded that it was sufficiently established that Thales will suffer irredeemable, irreparable, or insurmountable prejudice if the state were allowed to continue with the prosecution in the face of the deaths of Messrs. Tetard and Moino." The court added, and I quote, "The court seized with the matter, which we understand to be the court adjudicating the merits, has a duty to consider all the evidence before it, including the non-availability of defence witnesses, before returning a verdict." Against that background, we advance the following reasons why, in our most respectful submission, the applications for leave to appeal should be refused. The first reason arises from the legal principles governing midstream appeals in criminal matters. Although this is something that will be explained more fully by my learned friend Mr. Trengove in his argument on the state's application for an order postponing the criminal matter to a date for trial, what I do and should say at this stage briefly is this. There is a strong policy in our law that midstream appeals in criminal matters are generally not allowed. The general rule is that they aren't allowed because they unduly delay trials and may ultimately be irrelevant. For instance, if the accused is acquitted at first instance. One of the implications of this policy is that the trial court should generally not give leave to appeal against its midstream orders. They should be allowed, or such appeals should be allowed only in circumstances, and this is the principle established by the Western Areas case and Delport, and it appears to be common cause at any rate between the state and Thales, that this is a correct statement of the law, in circumstances which are so unusual that the interests of justice require a departure from the general rule against midstream appeals. That then brings us to the facts of this case. As will have appeared from any reading of your Lordship's judgment, in the present matter, the interests of justice do not require a departure from the general rule against midstream appeals. And the reason is the practical effect of the dismissal of the accused's application for orders quashing their prosecutions and acquitting them of all the charges before the trial even starts, is that the actual nature and extent of the prejudice to them arising from the deaths of Messrs. Moino and Tetard, as well as its impact on their constitutional right to a fair criminal trial, and specifically their right in Section 35(3)(I), will be assessed and determined by this court at the end of the criminal trial, or perhaps during the criminal trial, should this court find that it is necessary to do so. As this court with respect rightly held in its judgment, the trial court will have, and I quote, a duty to consider all of the evidence before it, including the non-availability of witnesses before returning a verdict. Consequently, we submit the present is not an instance where this court's dismissal of the two applications has caused or will cause them irredeemable, irreparable, or insurmountable prejudice. The brief submissions I'm now going to make on the merits are made in the alternative. We submit that the first reason alone is dispositive of these applications. They go to the issue of whether these applications satisfy the reasonable prospects of success requirement for appeals in criminal matters. One of the leading authorities is the case of Smith, 2012 1 SCR 567 STA at paragraph 7, often quoted, in which the court held that what the test of reasonable prospects of success postulates is there must be a sound rational basis for the conclusion that there are prospects of success on appeal. Dealing first with Thales's grounds, or more specifically those not already covered by what I've said. Thales alleges that this court erred in finding that it, that is Thales, had failed to place sufficient material before it to enable it to decide that Thales won't get a fair trial due to the deaths of Messrs. Tetard and Moino. With respect to our colleagues, this allegation is misdirected. The court did not make any such finding, nor did it make any subsidiary or minor finding to the effect alleged by Thales. Next, there is Thales's allegation that this court erred in holding that the evidence of Mr. Dryman and Ms. Gurrier can sufficiently substitute the evidence of Messrs. Tetard and Moino. With respect, this allegation too is misdirected. The court did not make any such finding. All it held is that if their evidence were to be adduced, then its probative value would be adjudicated in due course. Thales's next allegation is that this court erred in holding that the probative value of any evidence by them can only be determined at the trial. The implication of this being that this court could have and should have dealt at this stage already, sight unseen as it were, have held that the evidence could never have any probative value. For three related reasons, this allegation does not have reasonable prospects of success. First, although what was said by Messrs. Tetard and Moino during their consultations with Mr. Dryman and Ms. Gurrier is protected by Thales's legal professional privilege, and consequently neither of them can be compelled by the state to testify about it, it is open to Thales to waive the privilege and to seek to lead the evidence about that in an attempt to prove the truth of what they were told by Mrs. Tetard and Moino. Secondly, if Thales calls Mr. Dryman or Mr. Gurrier or Ms. Gurrier to testify on its behalf at the trial, and if through them Thales seeks to have admitted in evidence any contemporaneous notes made by them regarding what they were told about the events which have given rise to the charges against Thales, and doing that obviously in an attempt to prove the truth of what they were told, the state has made it plain in the main application it will consent to the admission of that hearsay evidence in terms of Section 31A of Act 45 of 1988, albeit without making any admissions as to the weight or probative value to be attached thereto or any part thereof. And thirdly, in that eventuality, as this court held, the trial court will consequently be able to determine the probative value of that hearsay evidence, and it will do so in the ordinary way, in the light of all the other relevant admissible evidence, including evidence which may corroborate the truth of what Mr. Dryman and or Ms. Gurrier may say, Mr. Tetard or Mr. Moino told them. Thales's next allegation is that this court erred in holding that it failed to show that Mr. Tetard would have assisted at the trial if he had been alive. Now, for four related reasons, that allegation has poor prospects of success. The first is that in Thales's November 2018 application for a permanent stay of prosecution, it alleged that Mr. Tetard was not prepared to assist it in any way not prepared to return to South Africa, and not prepared to testify in South Africa or any other forum should the trial take place. Secondly, in support of that allegation, in 2018, Thales put up an affidavit by Mr. Tetard, dated the 11th of March 2009, which is the court knows as Annexure AA10 at record 576 and following. And in that affidavit, he said he was not prepared to testify, and I quote, in any forum under any circumstances should a trial in this matter take place. One sees that at paragraph 48 on page 592. Thirdly, in its founding affidavit in the present case, which as this court knows was brought earlier this year, Thales doesn't explain when and why Mr. Tetard's attitude on its version changed in the period between November 2018 and his death on the 5th of September 2022, if indeed that was what happened. And lastly, despite this issue being pertinently raised in the state's answering affidavit in the present case, nowhere in Thales's replying affidavit does it explain when and why Mr. Tetard's attitude so changed. Thales's next allegation is this court erred in finding that the trial prejudice should be determined by the trial court, whereas this court is the trial court. With respect, it is clear from a contextual and purposive reading of this court's judgment that what it meant by the trial court, and we refer in this regard to paragraphs 14 and 17, is that it's this court after it has started hearing the evidence on the merits of the state's case against the accused. Thales's next allegation is this court erred in finding that the trial prejudice on which it relied should be determined by that court, in other words, the trial court, where its trial prejudice is capable of being ascertained at this stage. They went further to say it's already arisen, cannot be cured, and will be exacerbated by the trial. The fundamental difficulty with this, which is probably the mainstay, it's a conclusionary type of allegation of its case, is that those of its allegations which cannot be now refuted, such as, for example, the allegation about the availability of Mr. Tetard that I've just dealt with, but the rest of them, they all depend on speculation. Speculation as to the unfairness of the trial, as this court with respect rightly frowned. That brings me lastly to the few allegations raised by Mr. Zuma, grounds of appeal which are different from Thales's ground. The court will recall there is an allegation made also in the main case that this court, the allegation was made against the state then, misconstrued Thales's cause of action. Misconstrued it as being based on an infringement to have its right begin and conclude without unreasonable delay, section 35(3)(d) of the Constitution. Whereas in fact, Thales relies on an infringement of the right to adduce and challenge evidence, conferred by section 35(3)(i). The fundamental problem here is that Thales's main cause of action was clearly one of delay-induced trial prejudice. What Thales alleged was that the deaths of these two gentlemen, during the delay in the commencement of the hearing of the evidence in the criminal trial, has irremediably prejudiced its right to adduce and challenge evidence as envisaged in section 35(3)(i) of the Constitution. And the court clearly understood that to be the case because the judgment was directed at that. Secondly, there is another technical allegation, this time that the court erred in failing to recognize Thales's reliance on section 172(1)(b) to the Constitution. But as will have been apparent from my brief summary of this court's judgment, the court did approach the matter on the basis that it considered that Mr. Zuma's application for a declaratory order in terms of section 172(1)(b) should form part of Thales's application. Thirdly, there is another technical argument, Mr. Zuma's allegation that the court erred in failing to, quote, interpret and apply section 35(3)(i) of the Constitution purposively. However, none of the accused grounds for seeking an order, barring the prosecution before the trial on the merits begins, turned on a disputed interpretation of Section 35(3)(I). There was no argument, written or oral, addressed to your court on that. Instead, the issue was whether the evidence adduced by the accused in support of the application sufficiently established their cause of action. Then, another technical point, Mr. Zuma makes allegations concerning this court's findings, which I've described regarding Section 6B of the Criminal Procedure Act, and hence the competence of the order sought in the Thales Notice of Application. With respect, those grounds of appeal go nowhere, because as just described, despite this finding, the court did deal with the merits of Thales' application under the rubric of Section 172(1)(b). And finally, there is Mr. Zuma's allegation that there are other compelling grounds for granting leave to appeal. There are two aspects here. The first is it's based on a mistaken assumption that Section 117(1) of the Superior Courts Act governs this application. The court will recall that 17(1)(b) provides that other compelling grounds aside from the merits are a basis for leave to appeal. Whereas the possibility of an appeal at this juncture exists due to the judge-made principles governing midstream appeals described in the Western Areas and Delport cases. But secondly, and in any event, Mr. Zuma's attempt to rely on the deaths of Messrs. Moino and Tetard for an order quashing his prosecution is undermined by the simple fact that, as appears from the indictment, the state alleges that he personally was involved in the racketeering, corruption, and frauds with which he has been charged. It is open to him to testify in his own defense, as Mr. Sheikh did in his criminal trial. In the circumstances, there is no reasonable prospect of an appellate court disagreeing with this court's findings that, firstly, it is impossible for a court at this juncture to determine the actual prejudice to Thales and or Mr. Zuma arising from the deaths of Messrs. Moino and Tetard, and secondly, the nature and extent of the prejudice on the accused and its impact on their right to a fair criminal trial is properly to be measured by the trial court after hearing all the relevant evidence. And for these reasons, the State prays that the accused applications for leave to appeal be dismissed. Thank you, Madam.
Mr. Van Kroof.
May it please you, my lord. The Stop Stalingrad application is designed to put a stop to a strategy which has been employed in this case.
Just before you proceed, Mr. Van Kroof, can I just clear my mind on something here? Is it really necessary, or is it in the interest of justice to get into the merits of this application? And the reason why I'm saying this is because let's look at what is going to happen.
Lord, the water bottle is in our way, and thank you.
That's my secretary who put it there. Is it really in the interest of justice to enter the merits of this application? And the reason why I'm saying this is the following. What is going to follow is that the court will have to write a judgment. And once the court writes a judgment, a party that is unsuccessful is most definitely going to take the court's decision on appeal. And that is going to cause a further delay in the finalization of this matter. Now, a delay is one of the issues that have been raised many a times in this trial. And when I wrote my judgment on the last occasion, I did make a mention of the fact that this matter has been delayed for quite a long time. But I decided deliberately not to attribute a blame on anyone for that delay. Now, that's the reason why I'm asking, is it really in the interest of justice to enter the merits of this application, which is most likely going to cause a further delay in the finalization of this matter?
Well, my lord, with the greatest of respect, if there's any better way of avoiding further delay, then we'd be happy to go along with it. But our problem is that this strategy has now delayed this case for 18 years. And there is nothing to suggest that it will now end and that the accused will cooperate in allowing this matter to go to trial. What the strategy has involved consistently is the following pattern. The accused launch hopeless applications. Mr. Zuma has now, over the years, run 8 different interlocutory applications. Thales has been a party to 4 of them. They have, between them, delayed the hearing for more than 18 years. What those applications have in common is this. They have all been dismissed. They have, secondly, all been taken on appeal or on application for leave to appeal to the final limit. None of them have stopped short of the limit that the law permits. All of them have sought to appeal to the Constitutional Court if they were able to do so. But all of them have finally failed. And then there's another important feature about them, and that is that they were all consecutively run. They weren't all brought at the same time so as to be disposed of at the same time. They were all consecutively run so that if one application finally ends, another is launched. And so we go on the merry-go-round, which avoids the trial in this matter. The outcome has been that the administration of justice has been brought into disrepute, because it does appear that the administration of justice is incapable of bringing this case to trial. And that has no doubt been its purpose. So a way has to be found out of the conundrum caused by the Stalingrad tactic of delaying the case by interlocutory application after another on hopeless grounds, all dismissed, but all of them serve one purpose, and one purpose only, and that is to delay the trial. Now, you can't stop the accused from bringing further such applications. They are entitled to bring whatever applications they will, but what one can do is to refuse to delay the trial any longer, merely because there are such applications pending. And that, my lord, is the purpose of this application, is for the court to direct that the trial must go on, regardless of whatever pending applications for leave to appeal there might be in the background. And my lord, the order we seek today, we have little doubt will be sought to be taken on appeal. We hope to persuade your lordship to fight for us. We hope to persuade your
Exactly
lordship.
my point. That's
I beg your pardon?
exactly my point. That the
No,
order-
no, and that's why I'm addressing
Actually,
it.
whichever way I go, whether I find in your favor or in their favor,
Lord,
that decision is
but
most
let me
definitely
say,
going to be taken on.
Give us at least a hope of putting an end to Stalingrad, because we accept that if your lordship, we hope to persuade your lordship to find in our favor today. We will then hope to persuade your lordship not to allow leave to appeal. But we also accept that as a matter of realistic prospect, that the accused will probably seek to take that judgment on appeal. But at least, my lord, even if it should go on, even if leave should be granted, whether by this court or by the SCA, it at least gives us a prospect of a definitive judgment that brings an end to Stalingrad. If we do not pursue that route, the historical pattern that's been going for 18 years will simply continue. Your Lordship will refuse them leave to appeal in this application to stop the prosecution. They will apply for leave to appeal to the SCA tomorrow. If that application is refused, they will apply for a reconsideration in the SCA. If that is refused, they will apply for leave to appeal to the Constitutional Court. If that is refused, then the history shows us there'll be another interim application. And we can't simply resign ourselves to the fact that we are stuck in this merry-go-round which never ends and forever avoids the matter coming to trial. The accused must face their day in court. They can't forever delay that date. And, my Lord, so that we submit with the greatest of respect, we ask you today to put a stop to that tactic. And even if your judgment should be taken on appeal, we will ask the SCA or the Constitutional Court, if needs be, to intervene to put a stop to it. Because society and the criminal justice system can't just resign ourselves to the fact that we are captive to this tactic, which is designed to delay and has successfully delayed. And let me say this. The purpose of this application is not to punish the accused for their tactic. The purpose is to ask your Lordship to help save the reputation of the administration of justice. That is the purpose of the application. I don't know why the lights went off when I said that.
Maybe it's because of what you said. Yes, you may proceed, John.
Thank you, my Lord.
I don't want to appear on TV in any event, so you may proceed.
The purpose is not to punish the accused for the Stalingrad tactic. The purpose is to save the reputation of the administration of justice. And the administration of justice will continue to suffer
Just a moment, please.
disrepute, and the rule of law will continue to be under threat for as long as the administration of justice is seen to be incapable of bringing these accused to trial. My Lord, we highlight the facts set out in our timeline. The timeline is in the papers at page 28. I won't take your Lordship through it now, but it shows a long history of application after application after application, all of them sequentially brought. All of them failed. All of them went on appeal. All of them were dismissed on appeal. The only thing they achieved was delay, and they delayed for 18 years. So, as I said, we're not here to punish for Stalingrad. We're here to put a stop to Stalingrad. And let me also say that the state has also been at fault. The state should have insisted sooner that the trial go on, even if there is a pending appeal against the dismissal of some or other interlocutory point. The state has also been complicit in accepting that for as long as there is an appeal pending or an application for leave to appeal pending, that the criminal trial cannot proceed. We've realized that that is a mistake. We urge this court today to order that the criminal trial goes on, even if there is an application pending, as there now again is, for leave to appeal against the court's most recent dismissal of another hopeless application. And that is the purpose of the Stop Stalingrad point. And if we succeed here, but are taken on appeal, we at least have the hope that we will then persuade the highest court in the land to put a stop to Stalingrad. But we can't just accept that we have to live with Stalingrad. The state advances 3 prayers in this application. The first prayer is for an order to say that the trial must go on, regardless of what happens in the application for leave to appeal that you heard today, regardless of whatever further applications there might be for leave to appeal against your judgment. The first prayer is for an order that the trial go on. You can't deprive them of their right to apply for leave to appeal to the SCA and to the Constitutional Court, but you also need not stop the trial in order to allow them to do so. And that is why we're going to seek to persuade this court to order that the trial goes on, even if there are further applications for leave to appeal. The second and third orders address the effect of an application for leave to appeal, because it has been said that the effect of such an order would be to suspend something. We're not quite sure what, but we'll address you on the effect on your Lordship's existing judgment of the leave to appeal. But the first prayer is really the important one. That's the Stop Stalingrad prayer, the one that says, go on with the trial, even if there is a further appeal pending. Now, on that score, the first submission we make is that these applications, including these interlocutory applications, including the most recent one, may not be appealed midstream. And let me make it quite clear. We're not here saying that your Lordship's judgment may never be tested on appeal. We accept that it may, at the end of the day, after the criminal trial has been completed. But what the accused may not do is to do what they have done on every one of these applications of theirs as part of the Stalingrad tactic, and that is to appeal them midstream. They may not appeal them midstream, and the court should not allow them to do so. And let me say why we say so. There is a bit of debate about the law on the papers, and therefore I would ask you to allow me to just take it from first principles. The starting point is section 316(1) of the Criminal Procedure Act. What the section makes clear is that the right of appeal in a criminal case arises only after conviction. The section reads as follows. Subject to section 84 of the Child Justice Act, any accused convicted of an offence by a high court may apply to that court for leave to appeal against such conviction. So it is common cause between us, I believe, that the Criminal Procedure Act, at least, does not permit midstream appeals. Our courts have also held that there is a fundamental principle of our law that midstream appeals are not allowed. Appeals may be pursued after conviction, but not midstream. Then came the case of State versus Western Areas. My Lord, it's a judgment which is in our case bundle. Well, let me give the reference. It's 2005, Volume 5, SA, 214, SCA. And it was, and the date is important because it was a long time ago, 2005, 20 years ago. The law was developed since then. So, in the Western Areas case, what the Appellate Division did was again to emphasize the principle that in criminal trials, midstream appeals are not allowed. And it did so in paragraph 20, where it said the appealability of decisions of this court are based on the salutary general rule that appeals are not entertained piecemeal. Appeals are generally precluded before final appeals are generally precluded before final determination of a case, unless the judicial pronouncement is sought to be appealed against, whether referred to as a judgment, order, ruling, or decision, has three attributes. First, it must be final in effect. That means it must not be susceptible to alteration by the court appealed from. Second, it must be definitive of the rights of the parties. And thirdly, it must have the effect of disposing of at least substantial portion of the relief claimed. In other words, only a judgment which disposes of a substantial portion of the criminal case is appealable after conviction. But then Western areas brought about an exception to that rule. And the court based the exception not on the Criminal Procedure Act, but on Section 21 of the then Supreme Court Act. It did so in paragraph 25 and further. And what it made clear, what it did was to say, but the court also has, the Supreme Court of Appeal, also has a power to hear appeals under Section 21 of the Supreme Court Act. Supreme Court Act says it has a power to entertain appeals against any, quote, decision. So the court looked to the Supreme Court Act, Section 21, which gives it a jurisdiction to entertain appeals. And it says, what does that word appeal mean? And it concluded that power of appeal allows it also in criminal cases sometimes to hear appeals midstream, but only by rare exception. It came to that conclusion in paragraph 28, where it said, I'm accordingly of the view that it would accord with the obligation imposed by Section 39(2) of the Constitution to construe the word decision in Section 21 of the Supreme Court Act to include a judicial pronouncement in criminal proceedings that is not appealable on the Zweni test, but one which the interests of justice require should nevertheless be subject to an appeal. So it opened the door very slightly for appeals in criminal matters midstream where the interests of justice so require. It didn't overturn the rule as a whole, but merely made a small exception to it. There followed a second case that we wish to also highlight, and that is the case of Delport. It's SV Delport, 2015, Volume 1, SACR, page 620 SCA, which is in our bundle of cases at page 361. And why this case is important is that the SCA, again, emphatically and repeatedly emphasized the importance of the principle that in criminal cases, there generally is not a right to appeal midstream. And the court said so again and again and again in paragraph 20 through to 27. And it concluded in 27 that the general rule, underpinned by the Constitution, is against permitting piecemeal appeals. It is therefore in the interest of justice that criminal trials should commence and be completed without unreasonable delay, and that appeals should not be entertained before the trial is completed. But it still recognized the interest of justice exception created by the Western Areas case. Then came this court's judgment in this case. The judgment by His Lordship Mr. Justice Kun, delivered on the 16th of February 2022, it is SV Zuma 2022, Volume 2, SACR 378 KZP, and it is in our bundle of cases at page 377. Now, Lord, what His Lordship alerted us to and considered is this, and that is that the Supreme Court Act, Section 21 of the Supreme Court Act, on which Western Areas based its exception to the general rule, had been repealed. The Supreme Court Act has now been replaced by the Superior Courts Act 10 of 2013. And the Superior Courts Act destroys that foundation of Western Areas because it repealed the old Section 21, and in the new Section 1 defines the word appeal as follows. It says appeal in Chapter 5, that's the chapter that deals with appeals generally. Appeal in Chapter 5 does not include an appeal in a manner regulated in terms of the Criminal Procedure Act or in terms of any other criminal procedural law. So what it has done, it no doubt cognizant of the Western Areas exception in criminal cases based on the old Supreme Court Act, it specifically legislated that criminal cases are no longer, criminal appeals are no longer governed under the Superior Courts Act. So, the question that His Lordship, Mr. Justice Kuhn, had to address was what's happened to the Western Areas exception now that the Superior Courts Act deletes or repeals the foundation of Western Areas and makes it clear that criminal appeals are not governed by the Superior Courts Act, are only governed by the Criminal Procedure Act, and it is common cause that the Criminal Procedure Act says in 2016, without exception, that appeals may only be heard after conviction. So, His Lordship considered these matters and said the following, if I can draw your Lordship's attention to the following paragraphs. He says, he starts off by the starting premise, which is there are no Section 316 of the Criminal Procedure Act does not permit midstream appeals. He emphasized that in the following paragraphs, 37, 38, 43, and 51. Then he considered whether Section 35.3.0 of the Constitution allows a midstream appeal. And he concludes in paragraph 47 that it does not. He then considers whether Section 168.3 of the Constitution permits midstream appeals, and he concludes in paragraph 49 that it does not. And then he referred to the Western Areas exception and noted that it was founded on Section 21 of the Supreme Court Act, but made the point that that foundation has now been repealed. He did so in paragraphs 58, 59, and 66. And so on that analysis, he came to his overall conclusion in paragraph 76. that in fact the Western Areas exception has been repealed by the Superior Courts Act. His Lordship then goes on to consider whether there might be alternative bases. Well, he goes on to consider further contentions advanced to him, but in the hypothetical. In other words, his further consideration of the contentions advanced to him were based on the assumption that he was wrong in the first place to conclude that the law no longer permits midstream appeals. And he considered the various submissions made to him by my learned friends and dismissed them. But the point of the matter is that he considered those contentions only in the alternative, because his main conclusion was that Section 316 governs appeals in criminal matters. The Western Areas exception to that rule has now been repealed by the Superior Courts Act definition of appeals. So the ratio of this court's judgment is that the law does not permit midstream appeals, full stop. There is no longer any exception to that rule. So that is the first basis on which we submit, that any appeal or attempt to appeal against your Lordship's judgment will be unlawful and invalid because the law does not permit midstream appeals. And for that reason, it should be ordered that the trial proceed, because any attempt to appeal will be unlawful and invalid. Lord, but then we also turn to prayers 1 and 2, and they say, they are, as it were, address the assumption that we are mistaken on prayer 1, that the law does still permit appeals, at least in theory, midstream. The question then is, what is the effect of such an appeal? And more particularly, does such an appeal preclude the first prayer, which is that the trial proceed? Now, the question, in other words, what it postulates is this. What if this court, in the main application, in the application to stop the trial, refuses leave to appeal, but, as your Lordship has noted, the accused inevitably apply to the Supreme Court of Appeal and ultimately to the Constitutional Court for leave to appeal? Why should the trial proceed despite those pending appeals? Because they suggest that those appeals will suspend this court's order, and therefore that we can't proceed with the criminal trial. They say that happens under Section 18 of the Supreme Court Act, Superior Courts Act. So the question is whether Section 18 of the Superior Courts Act has the effect of precluding this court from proceeding with a criminal trial in the meantime. Now, we have 3 submissions on Section 18. We submit in the first place that Section 18 is not applicable at all. We submit in the second place that if Section 18 is applicable, then the applicable subsection is 18.2, and which applies to interlocutory orders, and it makes it clear that an interlocutory order is not suspended by an appeal. We submit in the third place, even if we're wrong on the first and second proposition, and that if that appeal is subject to Section 18.1, which creates the default rule of a suspension, then we ask the court to make an order in terms of section 18.1, and that is that the trial proceed. So let me just address those three main submissions. One goes back again to the definition of an appeal under the Superior Courts Act. As I said, Section 1 defines an appeal to exclude any appeal in a criminal matter, so that by definition, Section 18 doesn't apply to criminal appeals at all. And that should be the end of the debate, and that is not so, we submit with respect, is the position on a proper reading of the section. But that is also what His Lordship, Mr. Justice Kuhn, held in the case to which I have just referred in paragraphs 58, 59, and 66. So the whole Section 18 debate is misplaced. The section doesn't apply to criminal cases. Alternatively, if Section 18 does apply, then we submit with respect that it is Section 18.2 which applies. The section reads, subject to subsection 3, unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision that is an interlocutory order, not having the effect of a final judgment, which is the subject of an application for leave to appeal or an appeal, is not suspended pending the decision of the application or the appeal. So the question here is whether your Lordship's order refusing the application to put a stop to the criminal trial, whether that is an interlocutory order. An interlocutory order which does not have the effect of a final judgment. Well, my Lord, we submit with respect that it manifestly is an interlocutory order. And in fact, your Lordship's ratio made it clear that you made the order you did because the prejudice of which they complain can be properly addressed if and when it arises during the trial. So it is not merely as a matter of law that that order is classified as interlocutory. The judgment is in its own terms interlocutory and subject to change if it should appear in the trial that they suffered prejudice as a result of the delay. So we submit with respect that even if Section 18 is applicable, then it is Section 18.2 which applies, and Section 18.2, the default rule under 18.2 is that nothing is suspended. In the last alternative is then, if your Lordship should hold that we are wrong, that Section 18 does apply, that it is not 18.2, that it is not 18.2 that applies, but 18.1, then our submission is as follows. The question is, what is the effect of 18.1? Now, 18.1 reads as follows. Unless the court, under exceptional circumstances, order otherwise, the operation and execution of a decision, which is the subject of an application for leave to appeal, is suspended pending the decision of the application or appeal. So it says that the decision subject to the appeal, the operation and execution of the decision is suspended. But what does that mean? Your Lordship dismissed their application. What happens if one suspends your Lordship's judgment? What is that outcome? How does that help them? What it might in theory mean is that we must imagine that their application before your Lordship is still pending because your Lordship's dismissal of the application is suspended. But so what? How does that impact on the trial? So that And there has been a debate about its impact, but we submit with respect that if we apply the section to this case, to the facts of this case, and you ask yourself, what does it mean to suspend your Lordship's decision? Well, the operation and execution of your Lordship's decision is suspended. What does it mean? It means absolutely nothing. It might in theory mean that their application for the order is now, must be deemed to be pending. But what it doesn't say that the criminal trial cannot go on. So we submit with respect that whatever that prayer means, and whatever its impact might mean, its implication is not to require your Lordship to stop the criminal trial. So we submit with respect that the debate under Section 18 is an ill-founded debate, that it does not suspend the criminal proceedings, and that it does not pose an obstacle to the continuation of the criminal proceedings. And my Lord, for that reason, we submit with respect that the suggestion that the trial cannot go on merely because they propose to apply for leave to appeal here in the SCA and in the Concord is with respect unfounded. There is no reason why the criminal trial should not go on, why the accused should not have their day in court, and why the criminal justice system should not be vindicated to show that it will bring accused to court regardless of who they are. I thank your Lordship.
Thank you. Yes, Mr. Mpofu.
My Lord, due to the fact that this is mainly an application by Thales, between myself and Mr. Roux, we've agreed that he will go first, even though we are accused number one. That's good, please.
Yes, Mr. Roux.
That is correct, my Lord. And Mr. Mpofu said if my argument sounds good, he will then say nothing.
I appreciate that.
I thought you would, my Lord. My Lord, I'm not conflating the two applications, but there is of course some overlapping, and you have to forgive me when I do it from time to time. But may I start with a point raised by Mr. Trengo, which is to the effect that because the Supreme Court Act has been repealed, it means that Chapter 5 is no longer there in relation to criminal appeals, and it then means that this court has no discretion to allow midstream appeals. Not with respect, this is not so. May I just read an extract from the New Clicks decision, that's 2023, ZACC at 10. It's a well-known decision in a constitutional court. It is where a matter was advanced to the Supreme Court of Appeal at a time when the decision on leave to appeal was still pending.
Give me the full citation again.
If I may give the citation, it's Minister of Health and another. This is New Clicks, South Africa Pty Limited and others. 2023, ZACC at 10. And in this case, if I may just read this one extract, where it dealt with the interest of justice, because what happened is that, and ignore the fact that the late stage leave to appeal was refused. The argument was premised on the discretion of a court in the interest of justice to consider matters even on appeal. And in this case, the court said at paragraph 72, superior courts, meaning this court as well, have an inherent right to regulate and protect their own process. In the exercise of this power, they can decide whether or not to grant an application based on constructive refusal of leave to appeal and to penalise the litigant by a cost order where such an application is brought. And then there's a reference, and that's the important part, to Section 173 of the Constitution, which reads, "The Constitutional Court, Supreme Court of Appeal and High Courts have an inherent power to protect and regulate their own process and to develop the common law, taking into account the interests of justice." My Lord, and with respect, that is the law, and that is how it's applied. And if I may refer you, there's a pending matter before the Supreme Court of Appeal, awaiting judgment, and it's in State versus Lepondo, and you would have sat in the appeal, if I may say, my Lord. And I was the prosecutor sitting with the wrong or the right boot on my foot. And an appeal in the proceedings were raised, and they wanted to go to, and I opposed it. And I said the trial must go on. And I was successful. And the court found the trial must go on. And I'm afraid to say that.
And now the shoe is on the other foot.
The shoe is not enough, but I'm afraid to say that ultimately the Court of Appeal and Reconsideration granted the right, and the matter was then argued. And it was argued then on the merits of the special plea. So the court was acutely aware of the point raised by me that the trial should go on, and they took the point that was in the interest of justice to hear the appeal. And that concept then, when is it in the interest of justice, came back, that is not limited to this Supreme Court Act, but is relevant to the principle that, and that's still in the Western area, and that's untouched, and it's repeated in many, many, many cases, even in this court by Judge Kunisi then was, to say if it has the result to bring an end to the matter or curtail it substantially, that is the test. Then interest of justice would dictate that consideration be given to it. There's no blanket non-right to entertain it. That's not the law. And the question then before you is, if Thales is successful in its appeal, is it dispositive of the trial against Thales? Of course it is. Because the finding is then that you could not receive or could not receive a fair trial, and you were quite correctly pointed out, and I conceded an argument at the time, it's 172 that's applicable, and that was the correct relief and not phrased with Section 6. We agree with your analysis there. And that's the end of the matter then for Thales. It's dispositive of the case. Now, what is now so important to say that the court must find that, notwithstanding the fact that the appeal, if successful, will be dispositive of the case, that you must go on. If I may read, my Lord, I'm not going to repeat the heads of argument, it's there, I'm just highlighting. But if I read from the application, in the state's application, Thales' heads. And I will come back to this title, the Stalingrad application, to show why it cannot be, in our case, the Stalingrad application, and it's a misnomer. But in the heads, in paragraph 9, we refer to piecemeal appeals. And of course, it's beyond argument that it should be avoided as far as possible, unless it's dispositive. And the reference to the Western Areas case, where it deals with the principle that I'm reading, where it says that if decided in the accused's favour, would dispose of the criminal charge against him or substantial portion of it. By that example, I understand it would be implied there would be no trial or a substantially shortened trial. And then it goes on in paragraph 27 to say, it is surely not in the interest of justice to submit an accused person to the strain, expense and restrictions of a lengthy criminal trial if that can be avoided in appropriate circumstances by allowing an appeal to be pursued out of the ordinary sequence and so obviating the trial or substantially shortening it. And you have that power in terms of 173. And the test, as we'd set out in our heads, would be the interest of justice, and coupled with the interest of justice would be the harm element. And I'll return to the harm element by the state, which was really wiped off the table in the full court appeal in a private prosecution where the court said in relation to Mr. Zuma, but this harm is just that a trial can't go on now. But you're not precluded. It's not true harm because it can go on later. It's exactly on that point. So that's not true harm. On the other hand, when you force an accused to go to trial with an appeal that may be successful, not say it will be, that may be successful. If you force an accused to go to trial, he's in trial, and at some point in the judgment, if it's in favor, will then say, stop this trial in its tracks. And you think, what have we done? Why did we run this trial after 2 months to stop it? And I'm not saying what accused one will say on what impact that will have on accused one. I leave that aside. And what is going to be achieved? Just plain prejudice that can be avoided. Grave harm. If, of course, it is unsuccessful, the trial will run. And the harm is that it did not run sooner, it ran later. And that brings me back on this point of this Stalingrad delay. We all understand Stalingrad and we all understand delays. But to offer that to this court as a package deal in which Thales became a prominent player is, with respect, extremely unfair. And this court was absolutely correct not to take the opportunity and the invitation to make a pronouncement on the delay, because it would not have helped any party. It would not have led to any outcome that could assist either party. But if I may say, just on a factual basis, Thales brought 4 applications. The one was in relation to warrants to search. There was partial success. The second one was a permanent stay application in 2018. It was unsuccessful, but not prosecuted till the very end. The appeal was withdrawn ultimately. The racketeering application, where it was said, can you charge me with racketeering, was brought on as urgent basis as it could before the trial, not during the trial, not to delay the trial. And when it was unsuccessful, Thales did not appeal it. Thales said, let's proceed with the trial, and pleaded. And then Thales played no part in any further processes. It was the passenger, as we said. It was sitting here, and Justice Kuhn at the time, when I got up, he says, I assume you have nothing to say, Mr. Ruud. And I said, I have nothing to say. We're ready to go on to trial. That was repeated over and over again. Until this application where we then explained what we say the prejudice is. And this is where the important part in your finding comes in. Because my understanding of the case was, if this application is frivolous and an abuse of court, interest of justice can play no part at all. That's not your finding. That is not your finding. And this about being frivolous and abuse of court is repeated, that principle is repeated in many, many cases. Inter alia, the new cliques. And by Justice Kuhn, where he found that the process was not frivolous and abuse of court. But factually, I don't have to go there. The question is that this court find that it was frivolous or an abuse of process. No. On the contrary, if I may read paragraph 18 of this court's finding, it's very different, where it says, I am not persuaded that it was sufficiently established that Thales will suffer irredeemable, irreparable, insurmountable prejudice. Not that they won't suffer. It is different. It was that it was sufficiently established. So it was established, but this court found in its wisdom that it was not sufficiently established. May another court find that it was sufficiently established? Not if it was frivolous, not if it was an abuse, but it is an arguable point, and if I may explain why. An overview of the indictment is that Mr. Sheikh made payments to Mr. Zuma, categorized as unlawful payments, over a period of time. In relation to the general corruption, which is also the basis for the racketeering. The one piggybacks on the other. The allegation in respect of those charges is not that Thales made payments, is that they acted with a common purpose. Now, who would have acted with a common purpose? Who was in South Africa? Who was there when Sheikh was doing that, and who was on behalf of Thales there? De Taart and Manoy. They're not here anymore. Moving on to the specific corruption. The specific corruption is based on a meeting between Mr. Zuma, Mr. De Taart, and Mr. Sheikh to make payment, unlawful payment. They are the persons that can speak about the meeting. Mr. De Taart is no more. The payment, which is the basis for the money laundering, that payment coming from that meeting, the negotiation for the payment was between Mr. De Taart and Mr. Sheikh, though the case was it was a payment for a very different reason. But on the state's case, it was between Mr. De Taart and Mr. Sheikh. Mr. De Taart is no more. Now, I understand the court's judgment saying, well, maybe the legal advisors may assist. If that's the court on appeals finding, we lose. But if they say, can they really assist? Because it would mean for them to assist that, first of all, the facts would show that they were privy to the facts there, briefed on it, maybe, maybe not, but that's not where it stops. Now you must waive the most absolute right that you get, as described by the courts, and that is legal privilege. Thales must waive that now. And once you waive it, the legal advisor will be cross-examined on that, whatever knowledge they have. And they must answer questions, incriminating or not. So the legal advisor will now be forced to incriminate the client, whilst Mr. De Taart may not have done it, and Mr. Manoy may not have done it. But they now compelled to, because they're professional people and they may not lie to this court. I know sometimes I read the law reports that we do, but that they may not. They may not. And that's
choose your words very carefully. They may not.
They may not. Yeah, that's why I use two words. They may not. Oh. But now that right is gone. To not incriminate, you must answer the questions. The question may come, but can you say what was conveyed to you is the truth when it's an innocent explanation, I don't know. I don't know. That's what he told me. So the value, what is the probative value? It's nothing. So it's really accommodating of the state to say we will not object to the admissibility because they have nothing to lose. But we will not agree to the probative value. So what am I going to do with that evidence? And all we say, and the court may very well be correct in its analysis, but another court may find, would reasonably find, we say, that it is so devastating that there is no fair trial. Now, if that's the finding, and no one can say that finding is just pie in the sky, it's not. If that is the finding, then the trial will stop. So why go to trial when it may stop, when it may be dispositive, the appeal, the outcome of the appeal? Why? What has become so urgent? Is it a state's case that the witnesses are starting to tell them that if this case is postponed for another time, for another year, that they will not give evidence? That's not the state's case. The state's case is simply this: it's an administration of justice must call for finality. And I agree, but it's finality within reason. And as the full court said in the private prosecution, is the trial is not precluded, that will be harm. It will go on just later on. I'm curious what the later on will be. If the appeal is leave to appeal is unsuccessful and the further process unsuccessful, it will take some time, but not extraordinary time. If we go to trial and it's a long duration, you're not asked to postpone it to date X, so the trial will run. It is something that must happen, that you say, like in a declarative, the trial will go on and you must at point in time arrange dates. And long duration, to get these counsel on a 6-month trial to give you a date this year or next year. We've seen that for 6 months. We all have diaries already. So that's not going to happen. So the chances are even that, if not better, that the appeal process would in any event be concluded if the case is so bad as it is made out. If it is so terrible, but if it's not, the trial will stop. If it is so bad, that process can't just carry on and on and on. It must be concluded in some reasonable time. And then the interesting point about Section 18 in relation to this appeal. If the leave is refused, and let me rephrase, if the court grants this application for the state and there's an appeal, application for leave to appeal, it suspends it. That's 18.4. It's an automatic right. Let me correctly put it. It's an automatic right to appeal. And coupled with that, it suspends the judgment. Where does that take us? That process, why would that process be quicker? It says it must be done with urgency. But why would that process be quicker than one where the application is dismissed and dismissed and dismissed? And if you balance those two outcomes and say, does it really make sense to deny an appeal right in the sense that you're forced to go into trial and the right will become academic because if you go right through the trial and you're convicted, it's then set aside. Or you go halfway, it is then stopped. And you look at all the consequences to say, what is so frivolous and such an abuse, in this case, by Thales, to exercise that absolutely devastating option. Nothing, and I've dealt with your judgment. There is absolutely nothing. It's just that you sufficiently prove it, yes or no. Maybe another court will say so, but that's what it is. So, if the court would just bear with me. So what we submit to you, my lord, is, and if I may just make one submission on, insofar as it's relevant, and that is whether the repeal of the Supreme Court Act stopped any appeals before completion. I've already shown you that's not so. That's contrary to Section 173. But, and I think it was not on purpose, the submission to you was by Mr. Trengrove that Section 21 says that criminal appeals may, because of the repeal, no longer be advanced before completion. But it's not criminal appeals. It's different. It's appeals. It's not appeals in criminal matters. It's appeals in terms of the Criminal Procedure Act. And an appeal in terms of the Criminal Procedure Act is in terms of 315, only saying which courts must hear it, 316 to say it's after conviction, 319, 318, 319 on points of law. This is a constitutional one. This is premised on Section 172 of the Constitution. It is not, it says, the old 21, it's an appeal regulated by the Criminal Procedure Act. This appeal is not regulated. So it can in any event not apply. As to...
Are you saying it's being brought during criminal proceedings, but it's not a it's not a criminal appeal?
It's not an appeal in terms of the Criminal Procedure Act.
It's not an appeal in terms of criminal procedure act.
It's a criminal appeal in the criminal court, but that's not what
Brought during
Section 21 says.
Brought in the criminal proceedings.
Yes, but it's not one regulated by the Criminal Procedure Act. That's 316, 317, 318, 319, and 315, which court. And we said that out in the heads of argument. It's not the same. It's just an addition to show that that point's not good, but it's overtaken by the interest of justice. If I may say on Section 18, we don't believe that you need to consider the applicability of Section 18. And we say that in aids. We say what should be considered is the interest of justice. Whether Section 18 applies or not, what we can say, it is definitively not an interlocutory application. Because what was the application? The application was to stop the trial. That was the application. Now, an application to stop the trial is not interlocutory, it's final, it's the end of it. It's dispositive.
Just a moment, please. Yes.
It is not, what is the court finding that you can revisit it? That's something else. It is, what is the relief, what was the relief sought? Was that interlocutory relief sought? Or was it final relief? It's final relief. Stop. Stop. So, but it's academic input. Because we say we're not reliant on Section 18. Whether it's suspended or not, it's not important. It is whether it's in the interest of justice to carry on. May I just refer you to one quote? And that is paragraph 33 of the heads of argument on page 11 on behalf of Thales in relation to, we call it the state application, not the Stalingrad application, because we can't be accused of Stalingrad, not Thales. And I read from that paragraph, he's saying, this matter, when Kunjay, as he then was, presided, the court found in relation to the dismissal of the special plea and accused one's application for postponement of the criminal trial pending the outcome of accused one's application for reconsideration to the President of the SCA that, and I quote, it does not seem to me that this court has much of a discretion, if it has one at all, to deny those appeal rights statutorily ordained, unless perhaps in the clearest of cases there is an abuse of rights. The appeal process should be allowed to run its course. And the question is, why would you in this matter not allow the appeal process to run its course? What is the devastation that's going to be caused? I don't even want to say the trial will start later because I don't know if it will. I don't know how quickly the appeal process will be if it's unsuccessful. But if it's successful, it's irrelevant to talk about it because then it will stop the trial in any event. But if it's unsuccessful, then there's no argument and appeal dates. It's all on paper. And comparing that to a trial of long duration, getting the dates and when it will be ready, I'm not sure that that process will delay at all. But it may. It may, but it may not. So we don't know. And on what basis will the court then sacrifice an appeal process where the court's own finding is that it's not frivolous and not an abuse? What would the basis be? And we say that when you consider this and you weigh up for the interest of justice the harm, it's not a difficult outcome. It is one tipping, not tipping the scale, but the scale is falling down on the side of Thales to say there's absolutely harm there. But for the state, it will possibly start later. Possibly. Not to say it will. And we say in view of that, my Lord, that the application should be dismissed. As to the leave to appeal, we believe that there is prospects that another court would come to a different finding in view of what we have submitted on the analysis of the indictment, because there it is what we can see the prominence of Tetart and Monoy on the state's own indictment, and it is there that we say that another court may find or would find that there cannot be a fair trial. The last point is this, and it's said, and again, I've great respect for court judgment. It's really easy to read and apply the principles. I'm not suggesting it that not. It's just can another court come to a different finding on some of the aspects. It's not that you make gross errors that we say, look at this and look at that, that's wrong. It's not. But they say, and the court's findings, so Tetart, in any event, I'm not persuaded that he would have given the evidence. And it's correct that he said, there was a bit of ambivalence. He said in some places that I will give evidence in France, not here. In other places, he says, I will not give evidence at all. But that's not the test. The test is, what would Thales have done? When it comes to crunch time, can they compel him? Of course they can compel him. The court will assist him. If it's a crucial evidence, I don't care what Mr. Tetart's attitude was. You subpoena him, and he will be compelled to give evidence. He's a compellable witness. And I don't care what his preference may or may not be. So we say, my Lord, that A, there is a prospect that another court would come to a different finding, that leave to appeal should be granted. Irrespective of that finding, the application of the state falls short, fails to meet that interest of justice balancing scale of harm on the one side and harm on the other side, and that should be dismissed. Thank you.
May I just find out something from you, Mr. Roux? In the event that the court were to refuse you leave to appeal, how long will it take these appeal processes to be finalized?
Well, we have timelines. We have to file documents within set times. I think it's 30 days, if I'm not 30 days. We have to file timelines. If there's no merit, it can take a month, 2 months, 3 months. I've sometimes
But the appeal process could be finalized in 6 months tops.
That's what we say. That's what we say. It could be. If it's unsuccessful. Of course, if it's successful, it's a different question. But if it's unsuccessful, yes, because, and that's a point I made, if it is unsuccessful every time, meaning leave's not granted, you don't await dates from the SCA and from the Constitutional Court, for instance, whenever it can be heard. It's all on paper. It's all on paper. And you just get that little letter back to say, we won't hear you.
All right.
That's not that long time. It's really, it may be 6 months, maybe 8 months, maybe 5 months. It's difficult. Some I've seen quicker, some I've seen a bit longer.
And that's the factor the court should take into account when considering the application.
Absolutely. When you weigh that up and say, and when will this trial start? At best. And we say that in it on the probabilities. If there's no merit on the appeal on the state's version, then it should start in any event. The appeal process should be finalized before practically the trial could start. If it's successful, of course, it does not matter.
Thank you, Mr.
Thank you.
Yes. Yes, your turn, Mr. Mpofu. Looks as if we are going to finish before lunchtime.
Well,
Depending, of course.
in that case, let me get the pulpit. As court pleases, my lord.
Yes, Mr.
My lord, I agree with Mr. Roux and also Mr. Trengov about the overlap, or rather, yes, both my learned friends on the right and my left. And in line with the agreement, my lord, we will argue these two applications together. However, I will endeavor as much as possible, my lord, to separate them for a reason that I will explain now. And unlike Mr. Roux, we would prefer to start with the leave to appeal. But my lord, before I do so, you know, it is always said in law that context is everything. It's important to, and that's why we allowed Mr. Roux to go first, to understand the context of this application. That this is not our application, this is Thales' application. And it's easy to forget that because, you know, there's a media noise, Zuma is going back to court and all that. It's not Zuma's case. it's Thales. And the importance of that fact, my lord, will become clear as I argue my case. Because it will show Mr. Roux, as is repeated today, always refers to himself as a passenger, that he was a passenger for the past 4 or 5 years. Well, in this particular context, we are also passengers.
And he's the driver.
He is the driver. The only difference is that we are passengers who talk. He was a silent passenger. But passengers we are. And I'm going to leave your lordship with a thought on that point, which I will come to later when I deal with the second application, which is that let us postulate that we were indeed passengers like Mr. Roux, and that Thales would have brought their application in February as they did, and that we did not support it or oppose it. We just became passive passengers, so to speak. Then, my lord, I dare say that the second application would not have been feasible, because the second application is based on the so-called Stalingrad defense, which is pointed at us, not Thales, at least not seriously at Thales. And so the so-called Stop Stalingrad application is not Stop Stalingrad, it's Stop Zuma. Or it's a Zuma must fall application, which really has no place in these kinds of proceedings, because its only basis is to once again seek to denigrate the legitimate processes followed by Mr. Zuma, which Justice Kuhn held could not be stopped. But let's park that until we come to the Zuma must fall application later. My lord, the key to this, your lordship has asked pointed questions, and I'm afraid my learned friend, Mr. Trengove, failed to answer the question, and I don't blame him. It's because there's no answer to the question that your lordship posed as to whether it is indeed in the interest of justice or feasible to hear the second application. But we'll deal with that in due course. So let me keep my promise that we'll start with the tempting as it might be to deal with the second application. We'll start with the leave to appeal. My lord, with the greatest respect, the application for leave to appeal is one that lends itself to really very easy determination, and I say that with the greatest respect, my lord. And that is because, my lord, the basis upon which this court must grant leave to appeal is, of course, the usual basis, which is that another court would find differently. Mr. Roux has dealt with that extensively, and I will raise some of the points that he has not raised to support that conclusion. The lordship, of course, knows that there is the fallback section 17(1)(a) Roman 2, which where the court would, if it finds that there are compelling reasons why an appeal would be heard, and I dare say that there are, just purely from the novel nature of this matter. Both this application brought by Thales, and for that matter, the one brought by the new one now brought by the state, are quite unprecedented and novel, and all parties have acknowledged that. And as Mr. Roux said, Your Lordship might have decided it correctly, but that's not the issue. The issue is whether another court, that there are reasonable prospects that another court would find differently. For us, my Lord, the big point, which Your Lordship will appreciate, that another court, that there are prospects that another court would find differently, is this. Your Lordship made a gross misdirection or error in respect of the characterization of the application, stroke applications. And having said that, I will jump to Your Lordship's defense, because that error, my Lord, with the greatest respect, was initially caused by the state. And I will demonstrate how the state caused that error. But to some extent, it was also aided and abetted by the second accused, with respect to my learned friends. But one thing that is clear is that my learned friends for the second accused, in their pleadings, made it clear that what the case was not about. And my respectful submission, my Lord, is that there are reasonable prospects that another court might find that the court adjudicated exactly what we say the case was not about. And that was caused by the state which dragged the case, as it were, or redefined it conveniently. And I have my suspicions as to why they did that, but unlike them, I will not accuse them of having done so deliberately.
Sir, just a moment, please, Mr. Mpofu.
As court pleases me.
Yes, Mr. Mpofu.
My Lord, as court pleases, my Lord. My Lord, the shorthand to everything I'm going to say is this. All the answers to both of these applications lie in Section 35(3) of the Constitution. So that's really the headline of what I'm going to say. There is, my Lord, Section 35(3) is deliberately probably the longest section in the Constitution. Section 35 certainly is the longest section because it deals with fair trial rights, yes, broadly speaking. And these rights are many. We know that in the Sheikh case, it was said that they are interrelated. But that does not detract from the fact that they are separate rights which address separate problems, to put it colloquially. So in our respectful submission, the error with respect, my Lord, was that this case was run and adjudicated as if it was brought under Section 35(3)(d) of the Constitution. Whereas the case was, and we were at pains to explain this in our founding affidavit at least, that the case was actually brought under 35(3)(I), my Lord. And I will demonstrate very briefly, my Lord, why that mistake permeates the entire judgment and how it arose. Your Lordship will not need my convincing on the notion that fair trial rights as defined in Section 35(3)(d) are a separate and distinct matter to fair trial rights as explained in 35(3)(i) or any other, I think F is the right to legal representation and so on. All of them are different. And when the court inadvertently, with respect, then determines the matter on the basis of the one when it is the other, then that alone is a matter which a higher court would have to determine. So just that aspect, my lord, is sufficient for your lordship to grant leave to appeal. Because your lordship will simply be saying, well, I may have been right if the correct premise of the case had been determined. But I don't know what I would have decided had I looked at it differently. Now, my lord, I will demonstrate with reference to your lordship's judgment that your lordship decided this matter as a 35(3)(d) matter. The first sign is that your lordship's judgment is squarely premised on the accused, both accused, having failed to meet the test in Bothma versus Else. There's no doubt about it. My learned friend, Mr. Breitenbach, repeated that this morning.
Cases which were relied upon by both parties.
Well, my lord, if I may say something about that. Your lordship, again, and I don't think your lordship, I'm prepared to, your lordship says at the beginning of paragraph 11, in support of their contention for and against the grant of the declaratory relief, both the state and the accused relied on Bothma versus Else and others. Well, we definitely did not rely on Bothma versus Else, and that's why I was accusing, quote unquote, Mr. Roux. It is only to that extent. And your lordship, that's a small, it's not a ground for appeal. The point I'm making is that we deliberately did not rely on Bothma versus Else, because your lordship will remember that our entire case was based on the fact that this is not a 35(3)(d) matter. And that, my lord, Bothma versus Else is a constitutional court decision on 35(3)(d), not on 35(3)(i). And to make it clearer, you go to that, the reference to Bothma versus Else, my lord, you will remember is from paragraph 11 onwards. And it goes on, and then it quotes the test and so on. And then, in case there's any deep doubt, your lordship at paragraph 18 then relies on Sanderson for the conclusion that Mr. Roux referred to, that the case is insufficiently established and so on. Now, both of those cases, Sanderson and Bothma versus Else, are the primary authorities on Section 35(3)(d). So there can be no doubt that this court decided the matter as if it was a 35(3)(d) application. Now, the importance of that is this, my lord. Mr. Breitenbach correctly tells you that the test in Bothma versus Else, sorry, my lord. I don't want to misquote my learned friend. Yes, this is what Mr. Breitenbach said to you this morning. The test set in Bothma versus Else sets a high bar for the accused. And indeed it does. But then, if this court then set that high bar incorrectly, in other words, used the wrong test, which sets a high bar, then it means that in the event that another court finds that that was the incorrect test, then clearly the bar will be jumped, as it were. And so that's a serious ground for appeal, my lord. And again, I don't want to say that our learned friends dragged the case towards 35(3)(d) so that to set the higher bar. It was set by the courts. Why is that so, my lord? It is because, for obvious reasons, the courts are reluctant to simply stay a prosecution. I mean, this could be multiple murders and all sorts of things. So if you come and say, well, you know, I'd like the case to be stopped because it has taken too long, the court it has to set a high bar. That test does not apply to 35(3)(I) for good reasons. My lord, let me, before I develop that point, I want to demonstrate how this problem arose. If your lordship would go to 124 or 123 of the previous record, I'll take your lordship there.
Yes,
your lordship doesn't have to go right now. At paragraph 141 of the affidavit of our learned friends, of Mr. Downer, it says, this is now the gist of their defense. As matters stand, therefore, Thales has not established that due to the delay, so that 35(3)(d), and especially the deaths of Mrs. Moynot and Tettard, it will suffer any trial prejudice and is in the legally relevant sense, namely, and then they repeat exactly the Bodmer test, that the delay has inevitably and irremediably tainted the overall substantive fairness of the trial if it were to commence, because there is no way in which the fairness of the trial can be sustained. Those words come literally from Bodmer versus Ernst. And then they say, Thales has not established the exceptional circumstances necessary to warrant amounts to the extraordinary remedy of a permanent stay of its prosecution prior to the commencement of the hearing. So they responded to the matter as if the Thales application is a permanent stay application, which it was not. Then they say the proper course to follow and so on. Now, if you then go to the last paragraph of their affidavit, my lord, makes it clear it's 140. Lordship can just note that it's paragraph 192 at page 140, paginated page 140. This is now the coup de grace at the end of the case. They say, although the relief Thales is seeking is, as far as the state is aware, unprecedented, the state does not take issue with Thales seeking such relief because, in substance, it is seeking a permanent stay of prosecution based on alleged infringement of its constitutional rights to a fair criminal trial. Well, that was completely wrong. It was a deliberate, well, I don't know, I want to go that far, but it was a mischaracterization of the application of Thales, and certainly the application by the first accused. And that is wrong, my lord, because, and this time I'm coming in defense of Mr. Roux. Because in their application, sorry, my lord, I'll give your lordship the reference. In their application, and this was considered this morning, so again, I don't have to give you the reference. Thales specifically say that this is not an application in terms of 342A, 342 big A. Now, we all know that 342 big A is just a statutory codification of section 35(3)(d), because it simply explains how undue delay should be dealt with. And Thales specifically say, I think it's paragraph 81 of their founding affidavit, that 342A would not be appropriate in the present case. So it was incorrect for the state to mischaracterize that. Now, my Lord, with the greatest respect, that would be sufficient, because remember that ground permeates right through. Because if your Lordship, with respect, was unduly detracted to an off-ramp of Section 35(3)(d), then of course the implications of that would cover the entire judgment. And let me make this point, my Lord, to illustrate again that this is not just a semantic thing of saying 35(3)(d), 35(3)(i). The danger in conflating these two is exactly what happened. That they say, well, then there's no prejudice. And your Lordship, of course, in paragraph 18 says the same. But here's the catch. Prejudice a la 35(3)(d) is not the same thing as prejudice a la 35(3)(i). So just because you use the English word prejudice does not mean that the two prejudices are the same. Just as, my Lord, you accept prejudice when you are not given your right to legal representation is a different kind of prejudice. So all the separate steps in 35(3) have different types of prejudices. So the prejudice test that they used was the wrong prejudice test. And the court also therefore applied the wrong prejudice test. Because the prejudice, and that goes to Mr. Rue's core argument, the prejudice you suffer by undue delay and the prejudice you suffer by lacking the right to cross-examine are qualitatively and jurisprudentially different things.
To present evidence and cross-examine.
Absolutely. To adduce and cross-examine as the court pleases, my Lord. Because the prejudice of not being able to adduce or cross-examine is fatal and final and conclusive. It cannot be redeemed. Whereas the delay, you can find ways to ameliorate and so on. But here, my Lord, we are talking about, to put it crudely, witnesses, key witnesses who are dead. That's it. They cannot be resurrected. And therefore, the idea, the very idea, your Lordship, as I say, once the matter was using the incorrect test, your Lordship then came to the conclusion, which is my next point on the grounds of appeal, that the matter can be determined by the trial court. And here I'm not taking the technical point that this is the trial court anyway. Your Lordship meant during the trial. But the point I wish to make, my Lord, is that whether it's today, yesterday, next year, 10 years' time, Mr. Tetad will be dead. So he's not going to be more dead when the trial starts. That's it. And we cannot cross-examine a man who's 6 feet under the ground. Today, tomorrow, during the trial, after the trial, and forever. And therefore, that kind of prejudice, I'm simply making the point, my Lord, that prejudice is irredeemable and is determinable right now. We don't have to wait for anything which we might discover during the trial. We know already that... and this, my Lord, must be tied with the... And not even my learned friends can contest, my Lord, the fact that Mr. Tetad is a key witness, pivotal. If there's another big word, I'll ask Mr. Masuku for it. But the point, my Lord, is that this case, we must not forget what this case is about. If you walked around in the street, my Lord, and asked anybody, what is Mr. Zuma in court for? they're going to say it's the arms deal case. What about the arms deal? Encrypted facts. Everybody knows that. People who don't know all the facts about this case as we do know those two things. The author of the encrypted facts is dead. And unfortunately, that is the sad situation. May his soul rest in peace. But he's gone. And now, if the author of that crucial, that's the smoking gun in this case. The smoking gun is the so-called encrypted facts. If the person who wrote the facts, who says in an affidavit before your lordship, this fact is being misinterpreted. The facts, he says, it is not true that in these facts, encrypted facts, I was soliciting a bribe from Mr. Zuma. He says that. And that statement and the lordship will find that at 496 of the original record. And you see, because these things are glossed over, it's important, if your lordship allows me, just to read from the facts. Mr. Tetad wrote the facts on, the affidavit. After he had, remember, there was another affidavit where he had agreed to the authorship of the yes. Then he says, in his other affidavit, I was bothered by the fact that I had to do this cryptic affidavit that simply says I'm the author. And I kept on bothering the people until they said, okay, do the one where you want to explain. And he did. And this is what he says. At this stage, paragraph 4, I wish to state that I do not agree with the interpretation according to Annexure X, that's the encrypted facts, by the state. Furthermore, the state seeks to draw inferences from Annexure X which are not justified. It says, during and before the meeting I allegedly had with Mr. Sheikh, I was allegedly requested by him to arrange payment of a bribe by Thompson CSF to the Deputy President, Mr. Zuma. And then he says at paragraph 6, in response to the above, I wish to state 1. At no stage did Mr. Sheikh ever request from me or in my presence the payment of a bribe to the Deputy President. I'm jumping to the next important one. The document Annexure H was never, to my knowledge or on my instruction, typed or faxed. And then it says it was merely a rough draft of a document in which I intended to record my thoughts on a separate issues in a manner which was not only disjointed but also lacked circumspection. And then that's the gist, my lord. In other words, the author of the encrypted facts and this affidavit says it is not what the state says it says. Now, of course, your lordship knows sufficiently that that is the stuff cross-examination is made of. If Mr. Tetad was in the box right now, Mr. Roux has a right to call him to adduce his evidence to support his case. But we have a bigger right, my lord, to cross-examine him. Because, as your lordship knows, we have a right, the right to cross-examine even a co-accused. Both of those rights, in respect of Thales and ourselves, to adduce and to cross-examine, are contained in Section 35(3)(I), and both of them are gone forever. So the notion that this is an interlocutory application and all that is really just baseless. To crown it all, my lord, and I don't want to repeat the submissions eloquently made by Mr. Roux, what the state, and by the way, my lord, we also agree with your lordship on the section 6 point. I'm glad. I thought there was going to be another fight between me and Mr. Roo, but fortunately, he also agrees that your lordship was correct in terms of section 6. But with the greatest respect, that does not absolve the court from its responsibility to look into the matter in terms of 172(1)(b, because even Mr. Roo's prayer in terms of section 6 could be construed in terms of the wide powers that the court has in section 172(1)(b, but I'll leave that aside. Let me make this final point on the merits. So what is the answer of the state? It says, well, the lawyers are available. And the lordship, once again, correctly finds that on the issue of availability, there is a dispute of fact. And that dispute must be dealt with in terms of the Plascon-Evans case. No quibbles with that. Where we quibble with your lordship's finding is the second leg of that, which then says that that evidence may or may not be admissible. Because Mr. Roo is right. That evidence is, as we sit here, inadmissible. Or at the very least, they have the absolute legal privilege. But even if they didn't have a legal privilege, it's so speculative. That is speculative. How do we know? What did they say when they consulted with Mr. Tetat? What if, did he deny? Did he confess? We don't know. If he did, will they, if they say, well, he confessed or he denied, then what? How do we cross-examine them on that? So the right to cross-examination, even if your lordship is correct on their availability, is still curtailed because it's limited, let me put it that way. And when a right is limited or even threatened in terms of Section 38, then the court must declare that the right has been infringed. So, my lord, whichever way you look at it, just on those, I don't want to go into other issues, just on those 4 grounds, there is no doubt that there's a reasonable prospect that another court would find differently. And said, I don't even want to go to the Makate leg, which we have pleaded in our heads, my lord. And that's a crucial point, my lord, that, of course, your lordship, again, your lordship cannot be blamed for this, because your lordship gave this judgment in June. And then on the 31st of July, the Constitutional Court gave the decision in Makate. And the crux of I'm sure academics are having a field day about it, but in my respectful submission, the crux of the Vodacom Makate case, my lord, is to open a new avenue for appeal. So we have Section 17A1, Roman 1, Roman 2, and Makate. Because Makate says, in essence, paraphrased, and this is very important, irrespective of the correctness or otherwise of the judgment. And that's very crucial. So that means it negates Section 17A1. It says, irrespective of whether there's reasonable prospects and all those things, put that aside. Once the court has failed what the Madlanga J defined as the right to adequate consideration of a point put before it, then that judgment must be set aside. And with the greatest respect, my lord, we respectfully submit that this judgment, if we are correct, of course, on the D and I issue, then this court has, with the greatest respect, failed the adequate consideration test set in Makate, in the sense that the court adequately considered the 35.3D, but did not consider 35.3I. And my lord, I can get the ZACC of Makate. I'll give your lordship the reference. No. Can you get the ZACC reference? It's in our heads, my lord. We've referred to it in our heads. Yes, Makate, I'll just get it from our heads now. And this is at paragraph 63, my lord, of Makate versus Vodacom. This is what Matlanga ADCJ said. The adequacy of reasons, let's start at 62. Whether a court's reasons are adequate will depend on the nature of the case, the issues, and the ambit of the evidence and submissions. The test is not perfection, but adequacy. Adequate reasons do not necessarily have to be lengthy, as we know, my lord. Then I'll jump to 63. This is the crucial part. The adequacy of reasons is not concerned with whether the reasons are sound, correct, but whether they sufficiently explain how the court reached its ultimate conclusion. The reasons must be responsive to the case, live issues, and the parties' key arguments. The more complex and extensive the evidence and arguments, the more extensive will the reasons normally need to be in order to meet the test of adequacy. The reasons must be such as to enable the losing party to see that the court has decided the case that was argued and understand why that party lost. Reasons must also be such as to enable an appellate court to follow the court's reasoning with a view of assessing whether it was right or wrong. Reasons must disclose the path of reasoning. And to close that chapter, my lord, our respectful submission, if we are correct that the court was, as you say, waylaid, and therefore did not deal with the case before it, then the Makate test as well as the other tests have not been met. Then, my lord, if I may, then jump to the second application. And again, your lordship will forgive me if I jump back to the application for leave to appeal for purposes of illustration. Well, my lord, this application, and I agree with respect to Mr. Roux that firstly it's mischaracterized, sensationally called the Stop Stalingrad application. There's no such thing as a Stop Stalingrad application. It's an invention of the NPA. But if they have a freedom to call it what they want, we call it the Zuma must fall application. And as far as that application is concerned, my lord, and here I join issue with the cracks of that application. My lord, at paragraph 5 of our learned friend's founding affidavit, can you get me the paginated number, paragraph 5? They say the state brings this application because of the accused implementation of a Stalingrad criminal defense litigation strategy. Full stop. So there is the foundation of this application. Everything that follows in that affidavit is based on that. That's the very first paragraph that they put, paragraph 5, after identifying the deponent. In other words, in simple terms, my lord, for this application to succeed, this court has to find that Thales, not Mr. Zuma, is guilty of Stalingrad criminal defense litigation strategy. Because this is not our application. We are just mere passengers. We are used to being insulted, so it's fine. They can insult us. And for the purposes of this argument, I will say your lordship can assume, although we denied vehemently, that all the insults directed at us are justified. But that cannot then be automatically transferred to Thales, whose application this is. And there is clear concession, it's page 6, my lord. There's clear concession in their application that Thales is a half-hearted. Thales was a passenger, to use the shorthand. And you can read the affidavit, my lord, 100 times. You will find that the worst accusation against Thales is that they litigated, as they are doing now. That they litigated in the stay application, they litigated in the racketeering application, and they are litigating now. And therefore, that amounts to Stalingrad. Well, then what they are doing now, they brought an application now in October. Therefore, it's Stalingrad as well. Because in their language, merely to bring to come to court with an application is Stalingrad. But, my lord, they have two serious obstacles. And I'm using Thales as a reference point deliberately, my lord. Mr. Roux is more than capable of defending Thales. But to the extent that we are passengers in his bus, I have to use them as a reference point. The two problems are the following, my lord. Well, the first problem is the one that Thales cannot be, with a straight face, accused of Stalingrad. But the second problem, my lord, is that this is not the first time that this party brings the so-called Stop Stalingrad application. They can call it whatever they've called, but that's exactly what they did here in 2022, before Justice Kuhn. In brief, your lordship will remember, this was when the matter was before the SCA, and that goes to the pointed question your lordship put to Mr. Trenkov. Well, what happens, the losing party, whichever one it is, we now know the history of this matter, is going to appeal. And I dare say that if the state loses this, as Mr. Trenkov indicated, he says, your lordship give us so that a higher court. So already they've decided that they're going to appeal if they lose. But no, that's not Stalingrad. That's just exercising their constitutional rights. It's only Stalingrad if we do the same thing. But if your lordship goes to 212 of the present papers of the state's application, you'll see there the order granted by Kun J in the original Stop Stalingrad application. They were saying then that the matter should proceed because, irrespective of the fact that we are going to the SCA. And this court, and I must make this point, my lord, I've made this point before in a different context. Whether it is your lordship or Justice Kuhn or whoever is sitting on that chair, this court is this court. This court said in response to them, and you'll find this at 217, my lord. Justice Kuhn said, Mr. Zuma has challenged many decisions adverse to him in the past, usually invoking the entire appeal process to the highest courts in the land, and in many instances has been unsuccessful, which resulted in inevitable and unfortunate delays. Resulted. So that's, let me pause there, my lord. What this party is doing, my lord, is to confuse cause with effect, or intention with effect. The effect of litigation is delay. Nobody can deny. But is that the intention, or is that the effect, the inevitable effect of that litigation? And that's why Justice Kuhn called them inevitable and unfortunate delays. He then goes on. No, before I do that, my lord, let me just correct something, another misrepresentation. Mr. Trenkov described Stalingrad in exaggerated terms. He says, we've brought all these applications, all in succession, which is not true, all taken up to the highest court, which is not true as well. Because in our case, the case of the stay of application was not taken, it was taken, but it was not pursued in the Constitutional Court. And Mr. Roux has already told the court that their racketeering case, which is part of this, was not even appealed at all. So that statement is just untrue. And it's also not true that these were all successive. So, for example, the most recent, the private prosecution series of appeals and this trial were running concurrently at the same time. So it's not also true that there was this waiting and kind of relay type of thing. So even the definition of so-called Stalingrad is exaggerated for dramatic effect. Anyway, Justice Kuhn goes on. He says, he is also on record, he being Mr. Zuma, on record through previous counsel representing him that he will continue to exercise all rights available to him. But the exercise of those rights, here's the important part, the exercise of those rights, as much as they may be viewed with suspicion and distrust from certain quarters, as resulting only in delays which only favor him, do not per se amount to an abuse of those rights. A finding of malafides would require more and clear proof by the state, which I cannot make on the allegations in the present papers alone. Now, that statement, my Lord, was made in relation to the bad Mr. Zuma. How much more is that applicable to Thales, which has never until now been accused of Stalingrad? And why must their rights be curtailed? But even in relation to former President Zuma, when has this now been done? What Justice Kuhn said must be done, that you must bring more to show malafides. It has not been done. It has not been done in respect of us. It has not been done, certainly not been done in respect of Thales. And the other issue, my Lord, is that when the shoe was on the other foot, we went, this very same NPA is now being disingenuous about the prejudice. Because when we made the argument that they are making, we made it in the private prosecution. We said, irrespective of all this, let the private prosecution continue. And Mr. Roux quotes their response in their head. They said, what are you talking about? How can the private prosecution continue? Because Mr. Downer, who was the accused in that matter, will obviously be prejudiced. He'll have to go through the trial and the embarrassment and all sorts of things were said. And the court, including the SCA, agreed with them that it would be prejudicial for Mr. Downer and Ms. Mon then to be subjected to the trial while these appeals were continuing. Now, all of a sudden, there's no prejudice to Mr. Zuma and Thales if the trial continues and it is found. Remember, the formulation will be that the trial must continue and it may be found at the end that the trial was unfair, which is exactly what they were arguing. So it's a self-serving argument which is contrived and tailored for their own convenience. So this court would have to find, to grant them the relief, my Lord, this court would have to find that what Kuhn J said, or what this court said, was clearly wrong. Well, it was not even wrong at all, let alone clearly wrong. Because, as we know, in the rules of stare decisis, for the court to depart from its own finding, then it must find that it was clearly wrong. Well, there's nothing, with the greatest respect, that has been said in this case which renders that decision clearly wrong. But a more serious problem and a more direct problem that they have, my Lord, is your Lordship's judgment. Remember, my Lord, Well, every time the NPA opens its mouth, Stalingrad. I've been here for about 4 or 5 years. There's not a single procedure that has been said in this court without them invoking Stalingrad. And this current case against which we are appealing is no exception. Your Lordship knows that they went chapter and verse and put annexures of this size to demonstrate the so-called Stalingrad defense. We also went chapter and verse to demonstrate that actually they were responsible for more than half of the delays of the past 18 years. And by the way, I don't know, maybe the NPA is not well known for its arithmetic, but I find it very interesting that 3 years ago, they argued standing here that the delays of the Stalingrad were 20 years. Now, 3 years later, they say it's 18 years. So it means for the NPA, the years are shrinking. But be that as it may. What this court did, my lord, in its wisdom, was to say at paragraph, I think it's 10, my lord, of your Lordship's judgment. Your Lordship said, in the papers, the parties spent a considerable amount of time on the issue of delay in the prosecution of Mr. Zuma and Thales. It is common cause that there has been a considerable delay in the prosecution of both Mr. Zuma and Thales. It is common cause. However, says this court, in the light of the view I take on this matter, I do not consider it appropriate to engage in the exercise of attributing blame to any party for the delay. How, my lord? Of course, I have no doubt, my lord. All of us, we can put bets as to why your Lordship did that. But your Lordship did that deliberately, with your Lordship's eyes respectfully open, and for reasons which may or may not be clear to some. But whatever the reasons, your Lordship did it. Now, I ask this question rhetorically, my lord. How is the NPA going to jump over this hurdle? If in proceedings where we all went chapter and verse about Stalingrad, for and against, your Lordship said, I'm not going to decide the matter. I'm leaving it like that as to who's to blame. But this application cannot be decided, as we've demonstrated, unless your Lordship makes that decision. So your Lordship is now being forced, as it were, on appeal to revisit the decision that he said, I'm not going to make. Now you must make it, because there's no ways they can succeed without your Lordship having found that we're guilty of Stalingrad. And so is Thales. It's impossible to determine the second application without that finding. And they say so themselves at paragraph 5, that it's based on our alleged Stalingrad thing. Now, there's no cross appeal. If they said, no, His Lordship was wrong to take this approach, he should have decided the matter of Stalingrad. Then their duty would have been to file a notice of application to cross appeal on that point. And then the next court would maybe reverse that decision of your Lordship. But absent a cross appeal, this decision stands like this forever. And it's insurmountable on their part. And they cannot twist and force your Lordship to make a decision which His Lordship has deliberately, in the main judgment, said he's not going to make for good reasons. And without that decision, that's the death of the Zuma must fall application. My Lord, if I may just... yes. I will not, for the sake of progress, my Lord, I will hang on Mr. Baru's coattails on the issue of Section 18. Your Lordship knows that our position was that there could even be a constitutional challenge. We abandoned that, my Lord. And we want to approach the matter on the basis that Mr. Roux has said that Section 18 applies, which is the default position for Mr. Roux and the alternative for the other side. Now, if Section 18 applies, and by the way, my lord, let's assume Section 18 doesn't apply for a minute. It really doesn't matter. Because if Section 18 doesn't apply, then this matter would have to be decided in terms of the common law. And the common law was articulated in the South Cape engineering case, the well-known case. Section 18 is actually a codification of the common law. The common law simply said, if you appeal, you have a right of appeal, and therefore the default position is that it is suspended. Section 18 made it stronger and brought in exceptional circumstances and so on. But it is that position. So it really doesn't matter whether you apply Section 18 or you apply the common law. The point of the matter is that an appeal suspends. Now, my lord, Mr. Trengove says that the cases that he was referring to take away the right of appeal, so-called midstream appeals. Mr. Roux has answered that matter adequately. But, my lord, let me just bring a point that I said the answers to these things lie in Section 35.3. Here's the reason why my learned friend, Mr. Trengove, is completely wrong on this point. No case that he can read, or even legislation, can supersede the Constitution. The Constitution says, my lord, in Section 35.3(o). Remember, we've dealt with 35.3(d) and I. Now we go to O. Every accused person has a right to a fair trial, which includes the right of appeal to or review by a higher court. Full stop. Now, that, my learned friend, Mr. Trengove, takes you to Section 316, my lord, and says Section 316 talks about after the person has been convicted and so on. Now, that's exactly a point against him, because the right in Section 35.3(o) is given exactly to a person who has not been convicted. Because when the writers of the Constitution say every accused person, an accused person is a person who has not been convicted. If it was dealing with every convicted person, it would have said so. But once it says every accused person has a right to appeal, then it's talking about these two parties. And that constitutional right is sacrosanct. It is one where, my lord, the only way your lordship could limit that right is if there was a Section 36 limitation analysis. That has not been done by our learned friends. So that's the end. That's the killer to the alleged truncation of the right of appeal of an accused person. It cannot be done. And therefore, whatever they bring, the onus would be on them to then say, no, well, in this case, you must limit the absolute right of appeal of an accused person for this or that other reason.
In other words, the argument is that generally the court does not have the power to deny a litigant the right to appeal.
Absolutely. And if, or to limit, I like the language of Section 36, my lord, uses the word limit deliberately. And in Curry and Duval, they say these words are synonymous. Infringe, violate, limit means the same thing in the constitutional context. So to the extent that your lordship would be limiting the right of appeal of these two parties in any form by saying, well, unlike all the people in South Africa, who, when they are appealing, everything must be suspended. You, Thales and Mr. Zuma, only the two of you in this country, this will not apply to you. The show must go on. Both shows must go on, as it were. That, with the greatest respect, my Lord, would clearly and obviously be a limitation of the right of appeal. And the Lordship doesn't have the power to do so. And in our respectful submission, that point of Section 3530 is conclusive of the so-called second application. In sum, therefore, my Lord, what we are saying is that your Lordship, in the first application, ought respectfully to grant the leave to appeal, and in respect of the Zuma must fall application, your Lordship should dismiss it with costs. Well, I suppose we're not entitled to that. But if it's pursued further, my Lord, or maybe put it this way, if your Lordship were to grant the leave to appeal, then of course the SCA or whoever it is would determine the question of cost. But the second application must be dismissed, my Lord, on completely on its tracks. Let me just check, my Lord, with my.
Yes.
Thanks.
Yes, I saw them. They said no, nothing.
No, well, my Lord, you didn't hear. They said brilliant.
Yes.
Clearly, that didn't come from this side.
Yes.
My Lord, with the greatest respect, those are our submissions, and we have tried, as it were, to counterpose the two applications together, and the outcome of these applications must clearly be as prayed for in the notice of application for leave to appeal, and as stated in Thales and our answering affidavits, namely to dismiss the application. Oh, yes. As God pleases, my Lord.
Yes.
My learned friend, Mr. Masuku, was kindly asking me to hand over the pulpit.
I see.
As God pleases.
To Reverend Tengrove.
Yes, the Reverend
Tengrove.
Tengrove.
So who is going to reply? Is it both of you, or is it only Mr. Who is going to reply? Is it both of you, or is it only you, Mr. Tengrove?
Yes, my Lord, but we're limited to half an hour,
All right.
so we promise not to be long.
Okay. Do you want us to take a short adjournment, perhaps for 15, 20 minutes?
Yes, my Lord, because we have the 20 minutes as well, which we might not use. But it might be a good idea to take a
I
short
think it's best we take a short adjournment for 20 minutes or so.
Yes, until quarter past, my Lord.
We'll stand adjourned until quarter past.
As God pleases.
Quarter adjourned.
a Stalingrad tactic. Because he said his Lordship, Mr. Justice Kuhn, in an early case, held that on the evidence before them, the Stalingrad tactic had not been proven. Well, since then, 4 courts have held that their tactic is a Stalingrad tactic. 3 full bench judgments and an SCA judgment. In the SCA, we refer to them in our heads in paragraph 14. In 14.4, we quote the Supreme Court of Appeal as having held of their tactic that it was Stalingrad as follows. This abbreviated history illustrates, on any reckoning, the scale of litigation, which is likely unprecedented in the South African courts, justifiably attracts the epithet Stalingrad. And this is the clearest of cases. The private prosecution is part of the Stalingrad strategy announced by Mr. Zuma's counsel before Hugo J. So, the courts have repeatedly held that their strategy is a Stalingrad strategy, by which they mean a strategy designed to delay, to avoid his day in court. And what's more, Lord, not only have other courts characterized the strategy as a Stalingrad strategy, but in this case, Your Lordship has the benefit, which Justice Kuhn did not have, of exhaustive evidence on that strategy, set out particularly in our timeline of events and our history of the chronology of their tactic. Then my learned friend, Mr. Mpofu, says, but Thales is not guilty of Stalingrad, so how can you penalize them? We emphasize what I said in my opening. The purpose of the Stop Stalingrad application is not to punish anybody. Its purpose is not to deprive anybody of their rights to bring whatever applications they wish. Its purpose is to put a stop to the delay, in this case, by interlocutory applications, whoever brings them. So that it doesn't matter that that Thales was involved in 4 applications and Mr. Zuma was involved in 8 applications. The fact of the matter is that these interlocutory applications, the unsuccessful interlocutory applications, have delayed the case for 18 years. And the court has a duty in defense of the criminal justice system and in defense of the rule of law to put a stop to that process. And I emphasize again, we don't ask that any of their rights be curtailed. They can continue to bring any applications they wish, because we accept that we can't stop them from launching those applications, bad as they are. But what the court can do, and we submit with respect must do, is to say that I will no longer delay the criminal trial merely because there are these applications pending. I will go on with the criminal trial until a superior court stops me from doing so. But until that is done, the criminal justice system is being ridiculed by this case, by its inability to bring an accused to trial over 18 years without any end in sight. Our learned friend for Thales responded to our submissions on their right to appeal by invoking the court's inherent right to hear appeals. It's now not a right, he accepts, it's not a right under the Criminal Procedure Act, it's not a right under the Superior Courts Act, but it's an inherent right of the superior courts to hear appeals. But the answer to that is this. Of course they have a right to hear appeals, but it is not an unrestricted right. It is a right regulated by law. In fact, the Constitution makes it plain where it speaks of the Constitutional Court's jurisdiction to hear reviews. It does so in section 167(6). It says national legislation or the rules of the Constitutional Court must allow a person, when it is in the interest of justice and with leave of the Constitutional Court, to appeal directly to the Constitutional Court from any other court. So that right is recognized, but it is also conferred on the Constitutional Court as determined by national legislation. It's not an unregulated right. In this case, there is a right of appeal. The right is recognized under Section 316 of the Criminal Procedure Act. But the Criminal Procedure Act says you may exercise that right after conviction. You may not do so midstream. So they're not the section doesn't deny them of any right. The section regulates the court's inherent power of appeal by prescribing how it should be exercised. So to say that the courts have an inherent power to entertain appeals is to recite the obvious, but to that should be added that right is subject to regulation, in this case under Section 316 of the Criminal Procedure Act. My learned friend, Mr. Mpofu, on the other hand, says that they have a right of appeal under Section 35(3)(0) of the Constitution. But again, that submission is flawed for two reasons. Firstly, His Lordship Mr. Justice Kuhn held in his judgment in paragraph 47 that there is no right of appeal under Section 35(3)(0). So my learned friend's submission is contradicted by the binding judgment of His Lordship Mr. Justice Kuhn. But in the second place, all the Constitution does in 35(3)(0) is to says every accused has a right to appeal, full stop. It doesn't say every person has a right to appeal midstream. The right of an accused to appeal is recognized and entrenched in Section 316 of the Criminal Procedure Act. So it gives effect to the constitutional right, but prescribes the manner and timing of its exercise, so that it is the invocation of Section 35(3)(0), firstly, is precluded by His Lordship Mr. Justice Kuhn's judgment, and in any event does not take the matter any further. Lord, those are our submissions on the Stop Stalingrad application. My learned friend has a few.
Yes. Question?
Yes, thank you, my Lord.
Yes.
I'm going to deal with four matters. Firstly, our colleagues for Thales said Messrs. Tettard and Moino featured prominently in the indictment. And as regards Mr. Tettard, he added that even if Mr. Tettard was unwilling to testify, it would have subpoenaed him to give evidence. Now, our colleague's emphasis on Mr. Tettard is understandable, because in the indictment he does feature more prominently than Mr. Moino does. For example, he was at the alleged meeting with Mr. Zuma, which the state alleges gave rise to the so-called encrypted fax. The first difficulty with our client's submissions in this regard is that on the papers which served before your Lordship and on which your judgment was written, Thales's case was not that Mr. Tettard was an unwilling but compellable witness. Its case was that he was willing both to assist it in meeting the state's case and by testifying in its defence. In other words, Thales expressly relied on Mr. Tetard's willingness, had he been alive, both to assist it in challenging the state's case and to testify for it. Another difficulty is that when in the state's answering papers, as your lordship pointed out in his judgment, when Thales was confronted with its earlier version in its 2018 application for a permanent stay of prosecution, that Mr. Tetard was let me just put it this way. Another difficulty is in 2018, in the earlier stay of prosecution application, Thales' version was that Mr. Tetard was an unwilling witness. And when that was pointed out in the state's answering papers in the present application, and the state in those papers challenged Thales to explain in reply when between 2018 and his death in 2022, Mr. Thales' attitude changed. Mr. Thales' deponent was silent. They did not address that. And in the circumstances, you can assume and proceed on the assumption that nothing they could have said would have addressed that difficulty, the fundamental chopping and changing of their approach. Our colleague for Thales, and I'm now on my second point, for Thales also referred to Thales' legal professional privilege, protecting the secrecy of whatever Messrs. Tetard and Moino told the Thales lawyers, Mr. Dryman and Ms. Gurrier. And he submitted that if at the trial Thales nevertheless calls Mr. Dryman or Ms. Gurrier as witnesses to testify about what they were told, the state will be able to use its cross-examination of them to seek to elicit damaging evidence, in other words, evidence damaging to Thales' case. But with respect, the same problem for Thales would arise if Mr. Tetard and Mr. Moino were alive and they were willing to testify. And in the exercise of its Section 33 right to adduce evidence, Thales called them as witnesses. They too would be confronted. Sticking with Mr. Tetard, my learned friend for Mr. Zuma referred to and quoted from an affidavit which Mr. Tetard made on the 10th of May 2004. It is Annexure AA5 to the state's answering affidavit in the Thales application. Now, in that affidavit, Mr. Tetard firstly denied meeting with Mr. Zuma to conclude the corrupt agreement alleged by the state, and secondly, of the encrypted facts, Mr. Tetard said the following. The encrypted fact being, of course, the means by which the state alleges Mr. Tetard reported to his superiors on the agreement concluded at that meeting. Of that encrypted fact, Mr. Tetard said in this affidavit, this is his 10 May 2004 affidavit, that his manuscript document, which once typed in fact became the encrypted facts, was, and I quote, a rough draft of a document which I intended to record my thoughts on separate issues in a manner which was not only disjointed but also lacked circumspection, unquote. And secondly, he said he had never faxed the document or directed it that it be typed or faxed, but rather crumpled it up and threw it in a waste paper basket from where it was possibly retrieved and handed to the state. And so counsel's argument for Mr. Zuma was that if Mr. Tetard were alive and is called to as a witness for the defence, he could have testified in accordance with that affidavit. However, with respect, what my learned friend overlooked is that Mr. Tetard made an earlier affidavit on the 20th of April 2004, Annexure AA4 to the state's answering affidavit in Thales' application. In it, Mr. Tetard said he was the author of the encrypted facts. If Mr. Tetard were alive and is called as a witness, the state would have cross-examined him on, amongst other things, the apparent contradiction between his two affidavits. What my learned friend also overlooked is that, as explained in paragraph 36 of Mr. Downer's answering affidavit in Thales' application, the evidence in the Sheikh trial disproved the contents of the May affidavit, May 2004 affidavit of Mr. Tetard. I won't go into detail, it's given there. What it showed, essentially, that he was lying in this second affidavit of his, the May affidavit, about the encrypted facts. In that affidavit, his answer to Thales' application, present application, Mr. Downer also makes clear that the state intends leading evidence along the similar lines in the present matter if it goes to trial. Now, what all of this shows in our respectful submission is it would be wrong for a court to proceed on the assumption that Mr. Tetard would have assisted the accused in proving their innocence if he were alive and is called as a witness. More pertinently, we respectfully submit that the accused's submission that Mr. Tetard would have been an invaluable witness for the defence, like the rest of their case in support of their applications for the quashing of the prosecution, is based on speculation as to the probative value of his evidence. My learned friend for Mr. Zuma repeated and placed considerable emphasis on his contention that this court mischaracterized Thales' application as one brought under Section 35(3)(d) of the Constitution and not Section 35(3)(I). Consequently, he said, if I understood him correctly, that Botma versus Else and others, 2010, Volume 2, SA 622 Constitutional Court, is irrelevant, and this court's reliance on it constituted a fundamental misdirection. Our response to that is the following. Even a cursory reading of Thales' founding affidavit, and certainly a close reading, will show that its application for the quashing of the prosecution, or in that application, its main cause of action was one of delay-induced trial prejudice, resulting in infringement of its Section 35(3)(I) right. That was the case. Our second point is that Botma is the leading judgment in this country on cases of delay-induced trial prejudice. And it's perhaps useful to remind ourselves what that case was about. The submissions by counsel for Mr. Else are summarized in paragraph 26 of the Botma case. And I quote, "Counsel went on to urge that the fundamental rights of Mr. Else that were at stake were the right to be presumed innocent until proven guilty, the right to adduce evidence and to challenge prosecution evidence, and the right to a speedy trial." All three together. The real question, counsel argued, was whether it would be fair to put Mr. Else on trial when it was common cause that most of the material witnesses he wished to rely upon had died, and that the documentation to corroborate his defence was unavailable. The decades that had elapsed had forced Mr. Else into a position where he was unable to adduce evidence and would not be in a position to challenge the version of the complainant. Counsel contended that the dearth of evidence would inevitably render the trial unfair and created a high risk that an innocent man, nearly 80 years old, would find himself behind bars. Now, the parallels between that case and the present one are obvious, and I don't need to elucidate on them. But more importantly, and more devastatingly, if I can put it that way, for my learned friend's submission, is the Constitutional Court's identification in paragraph 30 of that judgment of the constitutional rights which were engaged. And I quote, "It will be noted that section 35(3)(d) and a companion section dealing with the right to adduce and challenge evidence. In footnote 19, it's footnoted to section 35(3)(i) of the Constitution, grants protection only to accused persons. He was not on any understanding of these provisions and accused persons between 1968 and the initiation of Mrs. Botma's prosecution." But the court brushed that aside, that technicality, and held in paragraph 36, "The delay in the present matter must be evaluated not as the foundation of a right to be tried without unreasonable delay, but as an element in determining whether in all the circumstances the delay would inevitably and irremediably taint the overall substantive fairness of the trial if it were to commence." And then from paragraph 67 onwards, the Constitutional Court addressed the trial prejudice on which Mr. Else relied and balanced it against the various constitutional rights which were implicated. I do not intend referring to anything there except save to say the following. In the matter before your Lordship, my learned friend, Mr. Roux, and his junior for Thales, and everyone on our side of the case were on the same page. We understood that this was a case about delay-induced trial prejudice, and that Botma versus Else was the leading authority. With the respect to my learned friends for Mr. Zuma, they have the wrong end of the stick, and their submission that your Lordship committed a misdirection is one which bears no reasonable prospect of success. Put simply, this court's approach to deferring until the criminal trial on the merits any decision on the trial prejudice on which the accused currently rely is, for the reasons I've just given and for the last reason which I'm now going to turn to, something which no court could reasonably quibble with. The last issue then I wish to deal with is what I understood to be the mainstay of the argument for Thales, being the lead accused in these matters. Great emphasis was placed on the interests of justice and what they rely. And you were urged to allow an appeal because if the appeal were to be successful, then Thales would have been put to the trouble and expense of participating in a criminal trial which would have to be stopped. The thing about that submission is that it presupposes that the grounds on which the quashing is sought bear reasonable prospects of success. And I've made my submissions in chief that they don't. In summary, what we say is this. Your Lordship was faced with the question, namely, do the interests of justice require that the accused trial be quashed? In the present application, the question is somewhat different. Do the interests of justice require that the accused be permitted to appeal against this court's dismissal of their latest applications for the quashing of the prosecution? For the following reasons, we submit the answer is no. Firstly, the practical effect of this court's dismissal of the quashing of prosecution applications is that at the end of the criminal trial, perhaps sooner if the court regards it as necessary, the court will address and determine two matters. The first is the actual nature and extent of the prejudice to the accused arising from the deaths of Messrs. Moino and Tetard. And as this court rightly held, one can only determine that when the evidence is in. The second, and let me just give us a practical example. The Tetard affidavit on which my learned friend from Mr. Zuma relied. Much can be said about it now, But when the state has led all of the evidence or similar evidence to that which it led in the Sheikh trial, which my instructions are, prove conclusively that the encrypted fax was indeed sent, the court will be in a position to assess, well, what value would Mr. Tettard have been as a witness if he'd come and given evidence along the lines of the 10 May 2004 affidavit. Right now, none of us here can, and certainly not the court, can answer that question. It is something which depends on the evidence. And only once that question is answered can one answer the derivative question, what prejudice actually did the accused suffer as a result of the deaths of these two gentlemen, and what's the extent of that? And once the court has decided on that, that is obviously something which needs to go into the scale. What the court has to then do with the Portman-Else balancing approach against the seriousness of the offence and all of the other factors that are mentioned is the court must adjudicate the legal question. What is the impact of the actual proven prejudice or established prejudice, if any, on the accused's constitutional right to a fair criminal trial generally, and obviously to their constitutional right to adduce and challenge evidence specifically? And if, as things turn out at the trial, it is established that due to the passing of these two gentlemen, Thales and or Mr. Zuma are unable to adduce evidence or challenge some of the state's evidence, and if, for that reason, having regard to that evidence, the trial judge were to further find that as a result, their right to a fair trial has been unjustifiably infringed, the trial judge will be empowered to take the remedial steps necessary to protect or vindicate the infringed right. Moreover, if as things turn out at the trial, as a result of a general lack of evidence, the trial judge is unable to make a clear determination of guilt on some of the charges, or perhaps all of the charges, then the presumption of innocence and the state's heavy onus of proving all aspects of guilt beyond a reasonable doubt will result in an acquittal on the charges in question. And it follows from all of this, with the greatest respect, that what the interests of justice now require is that the applications for leave to appeal be dismissed, and secondly, that the criminal matter proceed to trial, to the hearing, in other words, of the parties' evidence concerning the merits of the charges against the accused. Put differently, there is no good reason in the interests of justice to stop the criminal matter because the accused wish to appeal against your lordship's dismissal of their quashing applications. Those are our submissions.
Thank you so much for the presentation. Yes, thank you. Mr. Mpofu, your turn.
Thank you, Madam. As God pleases, my Lord. My Lord, I will again start with the Mr. Breitenbach section, the leave to appeal. My Lord, let me make this clear. In the application for the stay, it is true that what Mr. Breitenbach says, that Thales took the view that Mr. Tettard was unwilling and all that. But the court did not accept that. So the court is not bound by the version of Thales, this court. It's bound by what the full court found in that case. which was that Mr. Tetat could still be persuaded, let me put it that way, or brought one way or another to testify. And to be sure, my lord, Mr. Breitenbach accuses me of not referring to the earlier affidavit by Mr. Tetat, but I did. I said that the affidavit I was reading was an expansion because he was not happy with the first one. And that's the one that Mr. Breitenbach is referring to. And just for the benefit of Mr. Breitenbach, what I did not do deliberately in order not to mislead the court was to rely on the part in the affidavit of Mr. Tetat where he says, I'm willing to testify, but I'll do so in France. Yes. Which, by the way, is not the same thing as saying I'm not willing. And the reason I refrained from taking that point, even though it's favorable to us, is because in a subsequent affidavit, Mr. Tetat said, I'm not going to South Africa because they want to arrest me. So I didn't want to take that point for that reason. So the submissions were quite mindful of all the 3 affidavits that Mr. Tetat made. So the suggestion that we neglected the first one has no foundation. But my lord, here's the thing. Your lordship will remember that as with reference to Mr. Moino, if that's how it's pronounced, the court in the stay application at paragraph 156, the full court of this court, it says the same applies to Mr. Dryman, who's also still the current attorney, and here's the important part. Furthermore, whilst a claim has been made that Mr. Moino is alleged to be suffering from Alzheimer's, there was no medical evidence to support this averment. To conclude on this ground, even if there had been a delay in recharging Thales, they cannot be afforded the relief sought. So the absence of Mr. Moino was rejected on the basis that Thales had failed to produce the medical evidence, which is probably why they did not appeal at that point. Here, the situation is completely different, my lord. It is common cause between the parties that Mr. Moino has since passed on, and his death is irreversible. So that is as good as medical evidence as you are ever going to get, apart from the fact that by some miracle he might have recovered from his Alzheimer's, but he cannot recover from his death. So the situation here is completely different. My lord, the point we make about the mischaracterization of the matter is not a cheap point, my lord. It's a very serious matter. And that is why I was having attributed some of the blame to Mr. Roux for relying on Bodmer versus else. I did say that, in fairness to him, in the pleadings, they made this point very clear. And I couldn't find the passage, so I'll take your lordship to it's page 29 of the old bundle, paragraph 77, let's say 77 to 85, because I'm going to make other points in that same passage. And I'm going to quote their pleadings, my lord, to make three separate points. Let me start with the first one. The first point is, they say at paragraph 77, this is the Thales affidavit. In the first accused application for leave to appeal the dismissal of the special plea, Kun J again emphasized that, quote, The appeal will delay the criminal trial unreasonably, specifically as concerns Thales. Notwithstanding this, and 3 more years that follows, the delays continues to the prejudice of the second accused. That point, my lord, goes to Mr. Trenkov's section. And it simply says, is the point I made earlier this morning, that Thales was characterized by this court, at least, to the extent that there's a reference to so-called Stalingrad, as a victim of those delays. And now they seek to transform Thales to a perpetrator. And that's unsustainable, just on that basis. As I said, we deny any charges of Stalingrad. But even if you assume that those denials are unsustainable for some reason, then they cannot be automatically transferred to Thales. The next paragraph is paragraph 78, my lord. Now, this is where Thales makes it clear what their case is about. And they say, in terms of Section 38 of the Constitution, the second accused has the right to approach the court, I'm jumping, where its right to fair trial has been infringed or threatened, and the court may grant appropriate relief, including a declaration of rights. Let's just stop there. And this goes to the Makate point I was making, my lord. Where in the judgment does the court address the Section 38 case of Thales? Nowhere. So just that case alone is not addressed at all, for or against. Then they go on to say, my lord, this paragraph 79, I won't read it, makes the point that the prejudice cannot be remedied, which I already made. Here's the important part. Paragraph 80 says the second accused, that's Thales, submits that the prejudice as set out in this application will not be cured by any orders envisaged in Section 342 Big A of the Criminal Procedure Act. In other words, they disown any reliance on 342A stay of prosecution type of reliance. And the only just and equitable relief available in the circumstances is that the court direct that the prosecution be stopped, as is envisaged in Section 6 of the CPA. You can take out the last words as is envisaged because we all agree that that was on the construction of that section not applicable. But if that sentence stopped at is that the direct that the prosecution be stopped in terms of Section 172, for example, that would be correct. And then, as if that's not enough, paragraph 81, the one that I had referred to, says, in this regard, says Thales, Section 342A of the CPA contemplates circumstances where a court may eliminate delay and thus reverse any prejudice arising therefrom, and so on. And then it says the last sentence, as such, Section 342A of the CPA does not provide for appropriate relief for the infringement of the constitutional right to a fair trial to adduce and challenge evidence as envisaged in Sections 35, 38, and 172 of the Constitution. How much more clearer can it be that despite what they said in argument of wrongly relying on Botma versus else, that they had made it very clear that the case was actually not about Botma versus else. It's not about trial, so-called trial prejudice. So it's and all we have to do, of course, Your Lordship knows that what we're doing now is not to re-argue the case. We're simply saying another court faced with these passages that I've read, is it reasonably possible that that court would find that this case was about what Thales says it is about in those paragraphs and not about 35.3d? Of course it is. Then, my lord, the last point on the leave to appeal. Remember, my lord, that the so-called encrypted facts, which and we all agree now that's the big smoking gun in the case. Not only was its author Mr. Teta, But your Lordship will remember from the stay application that the evidence really about what happened with that fax came from Mr. Teta's secretary, a Ms. Delique, D-E-L-I-Q-U-E. Now, Ms. Delique, who was the informant, so to speak, has also since passed on. And so, even to the extent that Mr. Tetad would say, oh, well, this was never meant to be faxed, I just threw it in the waste paper basket. Ms. Delique maybe could have said, no, that's not true. He actually told me to fax it to Thompson and so on. But she's not here to even say that. So the case, with the greatest respect, is of those O.J. Simpson proportions of if the glove doesn't fit, you have to acquit. It's gone. It's gone with Mr. Moino, Mr. Tetad, and Ms. Delique, irretrievably. And so the case is gone. If they are gone, the case is gone. Then the last point, my lord, is the common purpose point. And I'm not going to belabor this point. I simply want to say, my lord, if I am charged with my learned friend, Mr. Masuku, for a common purpose, and then the common purpose by definition means that we must both be there. Now, well, I'm not sure how to make this example. If one of us goes away, probably Mr. Masuku, yeah, because he's not.
Because we have very quickly.
Yes. Correct, yeah. If one of us is no longer with us, my lord, it matters not that I might be the one who actually put a bullet on Mr. Masuku. It doesn't matter who's to blame. The point of the matter is that I can no longer be pursued for that common purpose. I might be charged for murder. That's a different matter. But the common purpose it cannot be sustained. So here, the players in this so-called common purpose are Mr. Zuma, Mr. Sheikh, Mr. Teta, and Mr. Moino to a certain extent. So the absence of a member, a key member at that, of the common purpose is fatal to the case, the case insofar as it is based on common purpose. And we know that the entire case is based on, as we say, I mean, there are many charges, but really it all centers around the so-called encrypted facts conspiracy. Then, my lord, with the greatest respect, then the leave to appeal ought to be granted just on those bases. Or at least nothing that Mr. Breitenbach has said displaces the grounds for the leave to appeal. Then let's come to the Zuma must fall application.
Our agreement was that my learned friend would have a right of reply on the leave to appeal.
Yes.
He doesn't have any right to any further address on the Stalingrad application. And that was not only so as a matter of law, it's also what we agreed.
Yes, Mr. Mpofu.
My lord, no, I accept, my lord, that the right of reply is obviously limited to where we are the applicant, where we're the applicant. But unless if my learned friend has an objection, I just wanted to make one overall point. No, well, he did it on the basis that there's no right of reply, which I concede, my lord. But I'm applying to the court to allow me to make a point, just to emphasize a point around McCarthy. Thank you. It's not going to take long, my lord. I just have
An objection has been raised.
Oh yeah. Yes. Well, if it's I thought Mr.
Yes.
Silence.
We do object. My learned friend must keep to the rules. We all have, and so should he. And I don't know how McCarthy comes into my case, except that I was in the case. But McCarthy otherwise has nothing whatsoever to do with the Stop Stalingrad case.
And it didn't proceed in the SCA.
Yes, my lord. Well, Mr. Trenkov is correct. He was in the case. And that case took about 18 years. And it was not called Stalingrad. But be that as it may, my lord, well, my lord, there's an objection, so I'm just replying. If your lordship just allows me literally 1 minute just to make a point.
Point has been made already in respect of the McCarthy. What more do you want to say on that?
Yes, my lord. It's a small point. I simply want to say, my lord, that the...
Sneaking it through.
no, I thought you were asking me.
No, Mr.
No, my lord.
Yeah,
Well,
yeah.
no, my lord. How it works is that I've made an application. Mr. Trenkov has objected,
Yes.
and now I'm replying so that your lordship can make a ruling
Okay.
as to whether you allow me.
Whether okay.
Yes. Yes. So I'm saying, and the point I wanted to make, I don't want to waste more time, my lord. Is the point is really quite tight. As a court, thank you, my lord. My lord, the point that has been made to your lordship is that the matter has been delayed for 18 years. Now, the only point I want to make, my lord, is that Mr. Trenkov rightfully has not addressed the question as to how do they overcome the fact that this court has decided not to enter that fray, and the fact that I respect the court's decision in that, but I want to make this point, my lord, please, that in the main application, your lordship will remember that we demonstrated, successfully or unsuccessfully, we will never know, but we demonstrated that of the 18 years Mr. Trenkov is referring to, at least 8 or 9 years is attributed to them, or to the period where there was no case. In other words, before the spy tapes case. Yeah. And therefore, the 18 years is a draw at best. And to the extent that your lordship did not enter into it, the point is that your lordship cannot now find that no, it's not a draw, and basically find against us on penalties. That's really the point at this stage of the case, my lord. If I can just check.
No, yes, he has got nothing to add.
Mr. Masuku is taking away his computer. As court pleases, my lord, the relief is as we stated earlier. We're indebted to the court and to our learned friends for cooperating and making this matter a one-day matter. As court pleases.
Yes, reply to your application, Mr.
It's not going to be a reply, rather is that, if I may just explain something. The reliance by Thales on Botman else was not on the delay factor. It was rather on the principles, because there were overriding principles to be applied that you could get from the Botma and else case. And it was in the sense that we submitted that we would not get a fair trial because of 35(3)(I), and in the Botma case it was said about when there's irreparable prejudice, it means that there is no way in which the fairness of the trial could be sustained. So it's in that respect that we may delay part of our case, but simply on the principles enunciated in the Botma case on the prejudice.
I'm expecting extempore judgment. Well, we have to adjourn this matter. I just want to bring to your attention the fact that I've got other commitments, as you would expect, Firstly, I'm doing duty in December. Then there's going to be a recess period. I'm supposed to go on leave with effect from January next year, but I will have to avail myself. I can only be in a position to avail myself on the 23rd of January 2026 if it suits you. It will be the first week of the session. Just for judgment in respect of both the state's application and the defense's application for leave to appeal.
If that will be for judgment, could we, those of us who might not be available, be excused? And obviously someone will be here to note the judgment.
All right. Does the same apply to you, gentlemen?
Does the same apply?
The same applies to us.
Right. Okay. And to you as well. I almost forgot about you. All right. This matter is adjourned to Friday, the 23rd of January 2026 for judgment in respect of both the state's application and the defense's application for leave to appeal. Mr. Zuma and a representative of Thales they are excused from attending the court if they so desire. Right. And the only reason why the matter has to be adjourned is because it's a criminal matter. We can't just leave it hanging or adjourn it in a day. Right. It has to be adjourned to a specific date. 23 January 2026 for the judgment in respect of both the state's application and the defense's application for leave to appeal. Both Mr. Zuma and a representative of Thales are excused from attending court on that day. Court adjourns.